sama satu from ethnic Batak Toba. Panomon Nomon dance in Toba Batak culture from North Sumatra has a meaning as a form of welcome and respect for guests to come, and that to show respect and warmth to guests, and is part of the traditions of welcoming important people or honor guests. The movement of this dance depicts gratitude and happiness for the arrival of guests and show the richness of Toba Bata cultures and customs.
Serious naval cases of credit card fraud at retail stores were reported to the police since
Emissions of greenhouse gases need to peak within the next 3 years.
One institution led the fight against corruption in Indonesia.
Peace, order, and justice are fundamental necessities for common life of human beings. Law is the primary instrument for realizing these prerequisites. But more than that, it is not only law that we need, but also governance and the law. The concept of governance itself is still a concept whose definition is not yet standardized. However, in the existing body of knowledge, the understanding of the concept of governance is increasingly developing in a more robust direction. Therefore, this conference has the scope to discuss the concepts of governance and the law under the theme Securing Peace, Order, and Justice Through Law. The conference has these following objectives. First, to develop an intellectual discourse on governance and the law, and second, to elaborate ideas and thoughts on understanding the role of law in securing human values, namely peace, order, and justice. This conference is in line with the vision of Faculty of Law Universitas Kristen Satyawacana, which reflects our dedication to academic and ethical excellence and affirms the role of law in building justice and harmonious society. We are pleased to welcome all participants to the Notohamidjojo International Conference on Governance and Law. Among the participants, there are 80 authors from Indonesia, Scotland, Singapore, and India. The conference is expected to bring academics, practitioners, and thinkers together to commit to the development of governance and the law. Welcome, authors.
Live from Faculty of Law Universitas Kristen Satyawacana, First Notohamidjojo International Conference on Governance and Law 2024, Securing Peace, Order, and Justice Through Law. Toba Dream Tortor Dance from ethnic Batak Toba. Toba Dream Dance is a contemporary dance inspired by the Toba Batak culture, often performed at important events as a form of cultural pride and identity. The dance depicts hopes and dreams, prosperity and well-being, connecting the past and the future through movements that blend traditions with modern expression. In important events, the Toba Dream symbolizes the spirit and noble ideals of the Toba Batak people to achieve a better life while maintaining their cultural values. Assalamualaikum, Shalom, Om Swastiastu, Namo Buddhaya, and Salam Kebajikan for all of us. Good afternoon, ladies and gentlemen. Welcome to the first Notohamidjojo International Conference on Governance and the Law 2024, Securing Peace, Order, and Justice Through Law, presented by Faculty of Law, Universitas Kristen Satya Wacana. Let me introduce myself. My name is Michelle Firelsia Septori. I will be the master of ceremony for today's conference on behalf of the organizing committee. In this blessed event, we would like to welcome Priyo Haryadi, SAMSI PhD AK, Vice Rector for Finance, Infrastructure, and Planning of Universitas Kristen Satya Wacana, Profesor Dr. Umbu Rauta, SHM Hum, Dean of the Faculty of Law Universitas Kristen Satya Wacana, Indirani Wauran, SHMH, Vice Dean of the Faculty of Law Universitas Kristen Satya Wacana, Dr. Christina Maya Indasari, SHM Hum, Head of the Master of Law Study Program, Faculty of Law Universitas Kristen Satya Wacana, Ninon Melatu Yugra, Head of the Bachelor of Law Study Program, Faculty of Law Universitas Kristen Satya Wacana, Abigail Prasetyo, SHMH, Coordinator of Innovations and Entrepreneurship Research at Faculty of Law Universitas Kristen Satya Wacana, Fredelino de Sousa, SHMH, Coordinator of Student Affairs, Alumni, and Corporations, and Mardian Putra Fans, SHMH, Coordinator of MBKM and Internship FAUKSW, Universitas Kristen Satya Wacana. We also thank our speaker for today's conference, especially for seminar session 1, Dr. Jefferson Cameo, SHLM from Satya Wacana Christian University, Alfatika Aunuriela Dini, SHMKN PhD from Universitas Gadjah Mada, and all of the presenter and participant of the NICGL 2024. Before we start today's conference, we will sing the national anthem Indonesia Raya, Hymne Universitas Kristen Satya Wacana, and March of Faculty of Law Universitas Kristen Satya Wacana. Ladies and gentlemen, may we all please rise. Thank you, everyone. Please be seated. We are grateful for the blessing of God's love. Today we can gather in good health and joy and in God's presence to attend this conference. To be grateful for that and to base this conference even on this, I would like to invite us to pray together. To Mr. Fredelino de Sosa, SHMH, you may come to the front to lead our prayer.
Ladies and gentlemen, I will lead the prayer according to the Christianity. So for those who with different beliefs, could pray with according to their respective religion. Let us pray. Lord God, Almighty Father, as we knew through your Son Jesus Christ, our Savior, we thank you for the blessing and your indescribable hand on us in all of our life, as the proven of your permanent presence with us. Dear God, we pray for our first Notohamidjojo International Conference on Government and Law. May your presence launch this event. We open our hearts and souls and bless our mind during this event until the end of this event. Come be with us, inspire us, and lead us into the truth as the wisdom you breathed into our heart. As the prophet told us, the fear of the God is the beginning of the knowledge. We submit all of this prayer and all of this our hope in the name of Jesus our God. Alleluia. Amen.
Thank you, Mr. Fredelino de Sosa. Let us hear the opening speech from the Coordinator of Innovation, Research, and Entrepreneurship Faculty of Law, Universitas Kristen Satya Wacana, Abigail Prasetyo, SHMH. So, Ms. Abigail, you may come to the front to give an opening speech.
Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, dan salam kebajikan. Good afternoon, our honorable guests. I have to say Vice Rector for Finance, Infrastructure, and Planning of Universitas Kristen Satya Wacana, Mr. Priyo Haryadi, PhD, and also Head of LPM, Mr. Adita Sutresno. Thank you for coming. Dean, Faculty of Law, Universitas Kristen Satyawacana, Professor Umbu Rauta, our esteemed colleagues, and also the fellow participants. It is an honor to welcome you to the Notohamidjojo International Conference on Governance and the Law. It is a unique opportunity for international collaboration and the sharing of knowledge in securing peace, order, and justice. This conference is designed to engage and stimulate a discussion to create an innovative research and exchange the groundbreaking ideas, especially in governance and the law, to provide standards through the fulfillment of academic roles. This conference aims to elaborate the development of legal studies knowledge in the field of constitutional and state administration law, the criminal law, the private law, and also the international law. On behalf of the committees, I would like to say thank you to all the speakers on our seminar session, the Dr. Jefferson Cameo from Universitas Kristen Satyawacana, and Ms. Alfatika Aunuriela Dini, PhD from Universitas Gajah Mada, Professor Andri Gunawan Wibisana from Universitas Indonesia, and Mr. Aderito de Jesus Soares, PhD from Timor-Leste, and last, Professor John Braithwaite from Australian National University. And also, I would like to extend my gratitude to all authors that have joined the call for papers from NICGL, and hopefully will present their paper tomorrow in the panel session. And last but not least, also thank you for all the committees for your hard work to prepare this conference properly. I hope this conference will be a rewarding and enriching experience for fostering a new collaboration for all of us, especially in the governance and the law. Thank you.
Thank you, Ms. Abigail. Now we will hear the welcome speech from the Dean of Faculty of Law, Universitas Kristen Satyawacana, to Professor Dr. Umbu Rauta SHM. You may come to the front and the floor is yours. Give the applause to the Professor Umbu.
Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera untuk kita sekalian. Selamat siang, good afternoon. Honorable Rector Universitas Kristen Satyawacana, who is represented by Vice Rector of Finance, Infrastructure, and Planning, Universitas Kristen Satyawacana, Mr. Priyo Hari, PhD. Head of Quality Assurance Institution, Universitas Kristen Satyawacana, Mr. Adita Sutresno. Distinguished official of the Faculty of Law, Universitas Kristen Satyawacana, esteemed speakers, Prof. John Braithwaite, PhD, Prof. Andri Gunawan Wibisono, PhD, Ms. Alfatika Aunuriela-Dini, PhD, Mr. Aderito de Jesus Soares, PhD, and Mr. Dr. Jefferson Cameo, respected lecturers of the Faculty of Law, Satyawacana Christian University, presenters, committee members, and participants. First and foremost, we offer our deepest gratitude to God for His boundless provision and love, which have made it possible for us to convene the first Notohamidjojo International Conference on Governance and the Law, scheduled for December 13 to 14, 20 and 24. On behalf of the Faculty of Law, Universitas Kristen Satya it is my honor to extend a warm welcome to all the speakers and participants of this international conference who have generously agreed to contribute to this important event in celebration of the 65th anniversary of the Faculty of Law, Universitas Kristen Satya. We hope that this international conference will serve as a valuable forum for academics, lecturers, students, and researchers alike to present their scholarly works on the theme of the governance and the law is securing peace, order, and justice through law is a subject of continuing relevance both today and in the future. The international conference will address several key areas, including constitutional and administrative law, criminal law, private law, and international law. We express our appreciation to the speakers, presenters, and participants for their invaluable cooperation and dedication to this event. Our gratitude also extends to the committee members for their meticulous efforts in organizing this international conference. On behalf of the Faculty of Law, Universitas Kristen Satya, we apologize for any shortcomings or oversights in the preparation and execution of this event. We invite you engage fully in the first Notohamidjojo International Conference on Governance and the Law, and may it be a fruitful and enriching experience for all involved. May God bless you and thank you very much.
Thank you, Professor Umbu, for the insightful welcome speech. Now, it is an honor to welcome Priyo Haryadi, SAMSE PhD AK, a Vice Rector for Finance, Infrastructure, and Planning of Universitas Kristen Satya Wacana. Mr. Priyo, we invite you to the stage, and the floor is yours.
Good afternoon, everyone. Assalamualaikum warahmatullahi wabarakatuh. Shalom. Salam sejahtera, Om Swastiastu, Namo Buddhaya, salam kebajikan untuk kita semua. Rahayu, rahayu, rahayu. Distinguished guests, esteemed scholars, respected colleagues and participants. I would like to extend a special welcome and gratitude to our distinguished guests. First, Professor John Braithwaite, PhD from Australian National University. Then Mr. Aderito de Jesus Soares, PhD, Deputy Chief of Party of the Accountability and Integrity Mechanism Program in Delhi. And then Professor Dr. Andri Gunawan Wibisana from University of Indonesia, and also Al-Fatika Aunerilia Dini, PhD from University of Gajah Mada, and the Dean of Faculty of Law, Professor Umburauta, PhD, and also the keynote speech, Chairperson Kamea, PhD from Satya Vachana University as well. Today, and also my friend, Mr. Adita Sutresna. Yeah. Okay. Today at Satya Vachana Christian University, we gather for the first international Notohamidjojo conference on governance and the law. Title, Securing Peace, Order and Justice Through Law. A pivotal moment of intellectual discourse that seek to explore the intricate relationship between governance and law in our complex interconnected world. At the heart of our gathering lies a fundamental quest to understand how law and governance can be powerful instruments in securing peace, order, and justice. These are not merely abstract concepts, but essential preconditions for human coexistence and sustainable social progress. The landscape of governance is evolving. No longer can we view law as a static set of regulation, but rather as a dynamic, interactive process that involves multiple actors, state and non-state, public and private. Our conference today aims to unravel this complex interaction across various legal domains, constitutional and administrative, are being challenged by rapid technological advancement, global interconnectedness, and emerging social needs. Cybercrimes, transnational challenges, environmental concern, and human rights issue demands innovative approaches that transcend a conventional legal framework. To our distinguished speaker and participant from diverse background and expertise, I extend warmest welcome. Your contribution will be instrumental in advancing our collective understanding of how governance and law can work together to address the most pressing challenges of our time. Let this conference be a platform of our critical thinking, constructive dialogue, and innovative solution. May our discussion today contribute to a more just, peaceful, and order society. Thank you very much for your attention. Wassalamualaikum warahmatullahi wabarakatuh. Shalom. God bless us. Thank you.
Now we invite Miss Abigail, Mrs. Ninon, Mrs. Maya, Mrs. Indi, Professor Umburauta, and also Mr. Priyo Haryadi to come to the front to open the first Notohamidjojo International Conference on Governance and the Law 2024, Securing Peace, Order, and Justice Through Law. And also head of LP UKSW, and give an official statement that the Notohamidjojo International Conference on Governance and Law as an annual event of the Faculty of Law Universitas Kristen Satya Wacana. The gong beating be remarking that the first Notohamidjojo International Conference on Governance and the Law 2024, Securing Peace, Order, and Justice Through Law, was officially started, and Notohamidjojo International Conference on Governance and the Law will become an annual event of Faculty of Law Universitas Kristen Satya Wacana. To Mr. Priyo Haryadi, Vice Rector for Finance, Infrastructure, and Planning of Universitas Kristen Satya Wacana, we are pleased.
Yeah, thank you very much. In the name of the God Almighty, I would like to open the first Notohamidjojo International Conference on Governance and the Law. Today, Friday, December 13, 2024. May His blessing will be upon us.
Give applause for opening this conference and making NICGL an annual event of Faculty of Law Satya Wacana Christian University. And we will have a documentation. Yeah, once again. Ladies and gentlemen, please rise and we will have the documentations, all of us. We would have a few minutes break to prepare for session 1 of the seminar. Ladies and gentlemen, now we have a break station. So if you want to take a break for have some snack or drink, you may go and please back in here at 3 p.m. Thank you. Ladies and gentlemen, now we have a break station. So if you want to take a break for have some snack or drink, you may go and please back in here at 3 p.m. Thank you.
I cannot even move my body. Can move in there. What's the thing? Starting now, but where's the volume? Goodness. So Ako, Hanila's awake. They're downstairs in their bedroom. Diba? How to go to get back to that? It's okay with the brother, okay? Babe? So you watching? I'm going down to check Lenore and Papa, okay? Okay, Jason. If you say it, you tell me, okay? Jangan cry. Jangan tidak akan kami. Kami dah orang kami. Apa itu? Cuma dia tak ada silang. Why are you crying?
Because I went outside and then he found
Meeting dah lain mana haru be. Aku sih sana tangan. How can I just still telepon tak mana? Ini yang lapis yang sound sir. So, I don't have place. Fine, then I'm going. Tama itu sekarang sih. Mano, emang mereka lah? Oke.
Ladies and gentlemen, we will continue our seminar during this part of the conference. The first session seminar will discuss about the role of non-state actors, society, and private entities in securing peace, order, and justice. Ladies and gentlemen, please welcome our moderator for first seminar session, Mrs. Indirani Wauran, SHMH. So Mrs. Indi, the floor is yours. Give applause to Mrs. Indi.
Assalamualaikum, Shalom, Shalom, Om Swastiastu, Namo Buddhaya, Salam Kebajikan. Ladies and gentlemen, our invited guests, our speakers for seminar session, I and all presenters, seminar session 1 and all presenters and participants, welcome to today's first seminar session on First Notohamidjojo International on Conference and Law. Before we start our session, let me introduce our first speaker because we have two speakers join this session. Our speaker first is Dr. Jefferson Cameo, SHLM, from Universitas Kristen Satewacana. And the second speaker is Alfatika Aunuriela Dini, SHMKN PhD, from Universitas Gajah Mada. Thank you for joining us. In this session, we will discuss about the role on non-state actors, which is society and private entities, in securing peace, order, and justice. Today, we explore critical insight into AI compliance and cybercrime law, highlighting how society and private entities can contribute to justice. Our distinguished speaker, Dr. Alfatika and Dr. Jefferson Cameo, will guide this discussion. So, for the first speaker, I'm happy to announce to have Dr. Jefferson Cameo SHLM with us. He has been lecturing at the Faculty of Law Universitas Kristen Satewacana for over 30 years. And Dr. Jeff obtained his Bachelor of Law from the Faculty of Law Universitas Kristen Satewacana, and he got his master degree from the Master of Program of Laws at Aberdeen University, Scotland, and doctorate from the Faculty of Law Universitas 17 Agustus Semarang, Indonesia. His thought produced many outstanding works with evidence of publishing 3 international accredited articles and more 13 national accredited articles. So without any further ado, I welcome Dr. Jefferson to give, please. Please. Okay. Yeah. Yeah, because we have both participants online and offline, Mr. Jeff. So yeah, maybe about around 100 or more join online, and you may start your presentation. And we will give applause for Mr. Jeff. Please, the floor is yours.
Okay, thank you. Mrs. Indi, Mrs. Moderator. Good afternoon, friends, colleagues, and also perhaps it is better for me to say, fellow researchers, because all of you are, I believe, researchers. So, okay, my title of this very, very difficult part of seminar is Indonesian cybercrime law, making human beings human. I will approach this topic, or this particular topic, the title, from a theory. And I have been using this theory since I took my doctorate degree from Surabaya. This theory is called dignified justice theory, or dignified justice jurisprudence. So if you, all of you, pay attention to the topic, I think you may be thinking that I'm going to speak about in the level of philosophy, but this topic actually should be approached using substantive legal basis, or people may call it doctrinal approach or normative legal research. But I will not use such an approach. I would prefer to use a philosophical basis. So that's why I put the theory on the third row of my title, which is a dignified justice theory or dignified justice philosophy. This topic is made, or was constructed by me using this guidance, two questions from the committee. They gave me this guidance or term of reference, two terms of references. The first one is the significance of criminal cybersecurity. I prefer to use cyber law phrase rather than criminal cybersecurity, because criminal cybersecurity is quite maybe far from law. So that's why I put in the bracket cybersecurity law. What is the significance of criminal cybersecurity or cybercrime law in preserving peace, order, and justice? The second guidance for me, the second tool of research for me, if you would like me to say like that, is what transformation. So the committee is dreaming of imagining that from this topic, we will get an idea about transformation from the government of the Republic of Indonesia in order to effectively secure peace, justice, and also order in the field of criminal law or cyber criminal law, particularly cyber crime law. So with these two questions in mind, please, next slide, please. Okay, we will look at the role of cybercrime law. Thank you for Faki, who making this PPT wonderful. This is roughly speaking, the role of cybercrime law. And if we see in this screen, we will find at least 6 roles that this particular subject may play in searching or in fulfilling the purpose of this seminar, which is securing peace, justice, and order. The first one, before we see the 6 of these roles that will be played or will be done by this cybercrime law, I think we should get the idea that crime law is divided into three aspects. The first is the substantive legal aspects, all the norms and also rules that the law has already there, or the people develop. And the second is the formal legal aspect or the procedural legal aspect. And the third is the preventive legal aspect. Many rules and also regulations and laws and norms are divided into these three aspects. But in this at this moment, I would like to discuss only the substantive aspects of this cyber crime law. So let's see the first role of the cyber law. Can you go back to the previous slide, please? Okay. The first one is identify standards of acceptable behavior. Standard of acceptable behavior for information and communication technology, or in this case, ICT. ICT, we abbreviated it as an ICT for the users. So the main role of this law is concentrate on the users. How the user will follow the standards of behavior that is acceptable within the law or according to the law, not according to another ideas, but only according to the law. We will see briefly about this substantive legal aspect, how this substantive legal aspect is fulfilled, fulfilling this cyber law role. The second is, the user in this case is human, or we call it natural person. We call it human, all of us. And the second is the society. In this case, legal person. Legal person in this case, we have already know, all of us have already know, is called as corporations. Corporations and also human. So either corporation and also human, they should follow this standard, acceptable standard of behavior that is within the law, in this particular case, I think within legislations, they should follow before they use the computer technology or the cyberspace. All of us. And the second is establishes the role, the second role is establishing social legal sanctions for cybercrime. So if friends, if you, colleagues, if you see socio-legals, what I mean by socio-legals is sociological aspect within the legislation, not outside the legislation. So that's what I mean by socio-legal. So in these ideas, this socio-legal, we will see how the society accept the sanctions, especially penal sanctions that is written in the legislation. I will show the legislation in particular to you after this. And the third role of cybercrime law is protects IC users. So if you follow the standard procedures, the standard behavior according to the law, the cybercrime law will guarantee us, all of us, and also the society, the protection for us as users of this technology. And so this is the the main aspects. It's protection for the users. And the second one is to mitigate. Mitigates mean to make something less severe. If something is already severe, the law will make it less severe. So it will guarantee us the protection in order to guarantee us all the protections that provided or guaranteed or given by the law. By mitigation, I think the law prevents harm or destruction or bad effects to the people and the society. This is the role of the third role of the cybercrime law. And within this third role is also the law, this kind of law, this branch of law, cyber law, is also protecting data. In this particular case, digital data. So I think in the society, friends, colleagues, in your research, you may find that we are, in this country, we are searching for a system that will provide us with the protections of our digital data, our name, our picture, our date of birth, our identity card or KTP. We should, the society is expecting a protection from the law, in this case, data protection. I will mention the law a little bit after this. And also the system, the systems. System means computer systems. So the law will protect the computer systems. So this is the idea, friends. I will not mention the particular norms or regulations, but the idea first, okay? And also services, protection services, not only goods, but also services. The law should protect not only human and society, but goods and services. This is the idea. And also the infrastructures. Many of our infrastructure in the society, maybe mainly in the government and also in the private sectors, need this kind of law. For what? To protect the infrastructure. Okay, this is very important. And the fourth aspect is protecting human rights. What is human right in this case is the privacy of individual privacy. Sometimes we in the society, especially in Indonesia, we are always sharing our stories freely in the internet. So this law will teach us how we should appreciate the human rights. In this particular case, the right to privacy. This is very important because sometimes in our society, we fail to pay attention to this particular aspect, which is human rights. In this case, individual privacy. And the fifth role of this cybercrime law is enables the investigation and prosecutions of crimes committed online in the internet. So in this case, I think we should discuss many rules and regulations with regard to procedural law, but I will not speak about that, as I have said before in the beginning of this presentation. So the sixth or the last role that this kind of law, the branch of law, cybercrime law in this case, role is transnationally. Transnationally means this is international law aspects. So this is quite a strange and very complicated branch of law. We should understand the international law aspects, or some people say transnational aspects. Because once we use the internet, we are not limited or bound by national boundaries. We are going internationally using, we are entering into very unlimited, unbounded jurisdictions once we use the internet. Because if, for example, if we would like to send an email to our friends in Russia, for example, maybe sometimes our email will step the path of the email. Maybe it will pass through London and then go to Russia, or maybe it will not go directly to to our friend in Russia, but it will pass to London or maybe in New York for sometimes, and then go to the destination, the final destinations of our email. So in this case, we must pay attention to the international law aspects, or in this case, transnational aspect of law. Also, transnational aspect in this case is facilitates cooperation between countries. We must not, if we learn this, if we study this particular law, the complication of this law is we should learn the comparative law. We should pay attention to comparative legal aspects. We should study every single legal system in this world who govern this cyber law or cyber space. So that's the 6 roles that that are expected to be played by cybercrime law. And next, please. Mrs. Moderator, please remind me if I have stepped the time limit. Step out the time limit, okay. Is it okay now? Okay. Let's see these ideas. Why the role of this particular branch of law? Why? Because we, in our constitutional system, it has already mentioned there, strictly mentioned in the first article of the Constitution about the rule of law. And we may find it in our old legal code, KUHP lama, the Act number 1 of 1946. In the Article 1 and 2, it was mentioned there about nullum crimen sine lege. Nullum crimen means there is no crime if there is no lege, there is no law. So these ideas suggested that we must provide in details, in a very clear manner, all the rules and regulations before we punish people with regard to these particular activities in the internet. So this is an old idea. There is nothing new if you follow me so far. And the second rule of law is we must see where the nullum crimen, or where the lege is, where the source is, or the sources are. I mentioned two main sources of law, and in the theory that I follow, the dignified justice theory, this theory teach us that if we want to look at what is called law, we should look at the Volksgeist. Volksgeist means the spirit of the people. The spirit of the people is represented by legislations. So some criticize me that I am too legalistic in this case, but that's the idea of law. So that's the rule of law. So we must make sure that everything that we are using as a standard must be written in a lege or the sine lege. It must be written in the law or legislation in this case. I mentioned two aspects, the sources of law in this case, and we call that the spirit of the people, or Volkshuis. The first one is statutory, and the second one is court decisions, permanent court decisions. So we have a very, very difficult agenda, very, very tough task as an academicians to do research in order to find all the laws and regulations, the substantive law that govern these particular activities in the cyberspace in Indonesia. This is the two sources of law. I mentioned in the bottom of this slide, all of these laws, we should not forget about Pancasila. So this is my point. Pancasila makes us or teach us to not feeling frustrated that we have no cyber crime. Pancasila guarantee us that we also have such kind of laws and regulations. The problem is, do we want to derive all the principles from Pancasila to make all of the details, rules, and norms with regard to this as using the internet or using the cyberspace? So this is the optimistic teaching given by this kind of theory for us. So we must not frustrate or frustrate if we find that there is no particular norms or rules regulating these activities in cyberspace. This theory teaches us. And one point of this theory is that all the rules and norms that we derive from Pancasila, in this case, rules and norms governing our activities in cyberspace, is having only one aim, one purpose, which is to make human beings human. So this is very important. If we do all of our legal activities based on these ideas, I think we will not get frustrated. And it will guarantee us to get or to find rules and norms that will govern us using the internet. Or in Japanese language, please correct me because I am not a Japanese people, nguwong ke wong, making human beings human or humane. Okay. Next, please. I hope, 10 minutes more left. So this is an international aspect that I have found already in my research to prepare this presentation. The world also find the similar problem that we have found in Indonesia. But not only problem, they also have found solutions that are similar that we should or we have already found in our Indonesian legal system. Countries are developing special laws. Okay, the phenomena is that countries are busy developing special legal norms in order to make sure to protect the users of the internet or the computer system. How they make this kind of or develop these special laws is by amending their national legislation. Like us in Indonesia, we are now amending our or totally change our old penal code, and the law number 1/2023 will be implemented maybe next year on the February next year, I think. So we are now preparing these new legal norms. And if friends, colleagues, and researchers are happy to read the law number 1, 2023, you will find there many aspects of laws, rules, and norms that governing these particular activities in the internet, using computers, using data, and etc. That's the first aspect, by changing the law, the old law, to catch up with the development of or the advancement of technology. In this particular case, the digital technology. And the second one is, as I have mentioned before, all of the countries in the world right now are also busy producing case laws, or we call it in Indonesia jurisprudency. All of the countries in the world are busy, very, very busy. All the judges are very, very busy producing this kind of rules and norms in the court decisions. So there are two sources of law, as I've just mentioned before, not only facing by us in Indonesia, but also now facing by all of the countries in the world, civilized countries in this wonderful world. And the next, please. So what is the substantive law that I mentioned that I will concentrate to discuss in this maybe 8 more minutes left? There are cyber-enabled. If friends, if you like to draw a red line on the left side of these slides, cyber-enabled means, yes, thank you very much. Okay, you see, cyber-enabled means there is no crime if there is no cyber. This is the fundamental characteristics of cyber law, is that cyber-enabled. If there is no cyber, there is no crime. So we only have traditional law or conventional laws, such as penal code, our old penal code. And in this old penal code, these rules and regulations mentioned in the old penal codes never mention cyber-enabled crime. Never mentioned. Okay, we will look at the legislation that is changing this old penal code later on. And then the second one is hybrid. Hybrid means cyber-enabled and then not cyber-enabled or conventional. And all of them, all of this cybercrime is called cyber-dependent. If there is no cyber, there is no such cybercrime. So 5 more minutes. Thank you for reminding me. And next, please. The 3 categories of cyber law. And so this is, again, I have found ideas in the system in developing this cyber law system is using a partial codification techniques. So we have a very, very tough agenda to do research in order to find rules and regulations that are put in or codified in many codifications, which is partial, not one particular code, but partial codifications. And also, as I have mentioned before, jurisprudency or case laws. Doctrines. Doctrine in this case means established teaching by professors and also textbook writers, and also developed by a very tough discipline legal research, which is led by professors or those who are very, very highly qualified in this particular legal aspect or branch of law. And also the other techniques is legal pluralism. If we try to approach these cyber activities, this kind of activities is activities that are conducted without reference to any particular political affiliations, religion, etc. Everybody can use this particular kind of activities. So that's why legal pluralism, when we approach this kind of law, we have to be pluralist, as pluralist society. We have to make sure that we are not sectarian based, for example, of sectarian bias, if you like. So this is all the ideas about substantive law to deal with cybercrime. And also next, please. Actually, we have in criminal law, we learn two aspects in order to approach every crime. The first one is called mens rea, and the second one is called actus reus. Actus means our activities, our real activities. Mens rea means our subjective mind. But all of them should be found in the formulations of the legislation. Whether it is actus reus or mens rea, it should be found in the formulations of the legislation. We will see them next, please. So this is, if we would like to look for mens rea, we have to see the purpose of the action. I found in my research, in order to make this presentation, I found them in the Article 30, Article 31, and Article 32 of the law number 11, 2008. And this kind of law has already been amended twice by the law number 16, 19 in 2016, and also the law number 1 in 2024, I think. So it has already been amended twice, but these articles, Articles 30 and 31 and 32, actually from Article 27 to 37, so 10 articles, all of these articles mention about purposely, the purpose of an act or the mens rea. So that's how the substantive law of these criminal activities, regulating these criminal activities, dealt with in Indonesia. And also the second one is willfully. Is it still in the time? Okay, selesai. This is still willfully. And the next, please. Latest one, please. Forgive if I have stepped offside your time. Negligently and recklessly. This is about against the law. If in the two part of the substantive law, purposely and willfully is the subjective part, these two is called an objective one. So both of them combined, we can solve the problem of cybercrime in Indonesia, I hope. So that's all of my presentation. Thank you for the time. And I hand it back this mic to Mrs. Moderator. Thank you very much.
Thank you, Dr. Jeff, for very nice presentation. And ladies and gentlemen, I noticed that Dr. Jefferson explores the role of Indonesian cybercrime law in protecting human rights and fostering peace and justice. He emphasized its dual function of establishing behavioral standards for ICT users and providing legal tools for the prosecution of cybercrimes. And the law, Dr. Jeff mentioned that the law is rooted in Pancasila and the dignified justice theory, aiming to make human being human, or nguwong ke uwong. Dr. Jeff also explore about cybercrime law that both insightful and inspiring, blending legal theory with actionable insight grounded in Indonesian's unique philosophical foundation. And his discussion on the nuance of criminal culpability and Indonesian hybrid legal approach highlighted his deep understanding of the law and its societal impact. His emphasis on protecting human rights and fostering international cooperation showcase a global perspective that resonates well with Indonesian legal aspiration. And of course, his clear articulation of the dignified justice theory and its application to cybercrime demonstrate exceptional depth and clarity, making significant contribution to advancing justice in the digital era. Thank you, Mr. Jeff. And going to our second speaker. In this session, we will have Ms. Alfatika Aunuriela Dini SH MKM PhD. Join us from Yogyakarta, I think. Miss Alfatika.
Hello, good afternoon, honorable guests, ladies and gentlemen, and also Ibu Indirani. Thank you so much. Hello, Ibu.
Okay, please check Ms. Alfatika on Zoom. And I will introduce Ms. Alfatika. She is from Universitas Gadjah Mada, and she has competencies in civil affairs, and she is also the head of international affairs, Universitas Gadjah Mada. She completed her doctoral program in information system and law, University of Agder, Kristiansand, Norway. Kristiansand, and Norway and FIFO training, QSR International 2016. And she also has overall synthesis score of 194 with a total of 5 international accredited articles and 9 national accredited articles, and that all making her one of the outstanding women in Indonesia. To Ms. Alfatika. Ms. Alfatika, could you
Yes, can hear you clearly, Ibu.
Okay, to Ms. Alfatika, PhD, the floor is yours. You have about 30 minutes to present your presentation.
Okay, thank you so much. First and foremost, I would like to check whether my voice is audible. Yes? Ibu. Yeah, thank you so much. So I would like to extend my heartfelt gratitude to the Honorable Dean of the Faculty of Law, Universitas Kristen Satya Wacana, Professor Umburauta SHM Hum, and the Deanship of UKSW. And I feel very honored today to be one of the participants for the first Notohamidjojo International Conference. And please bear with me. In the next 20 minutes, I will present food for thought and food for the mind on the discourse of the future avenues of artificial intelligence in the business law field in Indonesia, especially related to data protection and privacy. And I would like to also check whether my presentation is already visible in the screen. Yes? Yeah. Okay, I suppose it is visible. So I may go on. So Bapak, Ibu, ladies and gentlemen, this is the directory of my presentations that I hope that we could have a very fruitful discussion at the end of the presentations. And when we talk about innovation and protection of people's rights, it needs to strike a balance, Bapak, Ibu. In the digital arena, innovation, we believe that it is at the heartbeat. And regulation is, on the other hand, is the firm hand that keeps the rhythm going. And I think the difficulty stems from the quick pace at which technology changes, leaving a regulatory system unable to keep up. As in our proverb, or in our Latin word, is het recht achter de feiten aan. So the legislation always lag hand the practice. And consider the exponential development of AI, for instance, Bapak Ibu. This technological advancement promise extraordinary breakthrough, but they also raise concerns about data privacy and security. And therefore, today I will talk about first the regulatory development in Indonesia regarding digital technology, especially AI, and then the challenge of AI use and compliance to data protection law. And then the third one, I will also talk about the company responsibilities in using AI to process personal data. And this discussion will include the status of AI in the Indonesian regulatory landscape, whether AI can be considered as a legal subject or legal entity or not. And the last one is consideration to ensure AI use complies with the PDP legislation. So this is the landscape of regulatory developments in Indonesia regarding digital technology, Bapak Ibu, especially in addressing conflict between innovation and protection of people's rights. And we can see that the first one is law number 27 of 2022 concerning personal data protection. This is an important milestone in protecting the privacy and rights of citizens in the digital era. The concept of the right to privacy through this legislation, especially about personal data, inherent in each person, is then divided into several types. The first one is the privacy of information, physical privacy, privacy to find identity, and privacy of property, in which more specifically, they also divided into a specific, what is it called? Like the privacy, specific type of data, and then the general type of data privacy. And then the second one is the agreement clauses that contain requests for processing of personal data. It now becomes a must, meaning that it must be stated explicitly in every application, every website that gather, use, and process data from the users. And if not explicit, meaning that it has to be either written or recorded, then the agreement itself can be declared null and void. This is mandated by the Article 23 of the PDP law. And then in the field of business law, especially in the financial sector, we know that the Financial Service Authority, OJK, and also the Central Bank of Indonesia, they have issued various regulations to regulate fintech industry, including peer-to-peer lending, and then digital payment system. And the other thing is about cryptocurrency that is now being considered as a digital financial asset. And furthermore, provider of financial service sector or financial services industry, they must be registered and obtains permit to operate. And the number 4, that is also one of the biggest, not the biggest, but one of the major legislation in the digital era is the IET law, which was amended latestly with the law number 1 of 2024. And this includes several significant items that reinforce the electronic transaction system, such as the electronic system organizers or provider, or we call it penyelenggara sistem elektronik, and then international electronic contract. And one of the most important thing is they already also included the child protections clauses within the amended IET law as users of electronic system. And the last one is, this is directly related to AI, which is the circular letter of Minister of Communication and Informatics, number 9 of 2023, concerning artificial intelligence. The circular letter is actually addressed to business actors with artificial intelligence-based programming activities, and then public and private electronic system providers. However, for the circular letter itself, this is in a form of soft law, so non-binding instrument. And this circular letter is not included in the category of laws, of course, because although this document only serves as a guidance and issued by the Ministry of Communications and Information, now the Ministry of Communications and Digital, this circular letter is, in my personal opinion, is still important. And I think this initiative is a quick response from the government to address the dynamic development of artificial intelligence in Indonesia. Okay. And these are some of the cases that are emerging on the data protection and privacy. And for specifically on the artificial intelligence, we now know as well that a lot of state-owned enterprises, private sectors, banking sectors, and financial sectors, they start incorporating AI in their business process, such as this one is only 2 examples. They have Vira and also Mita as the AI chatbot for increasing the user experience in the banking sectors. And this is the latest survey on the emerging technologies in the financial sectors. We see that, there are a lot of emerging technologies. CBDC is the lowest of the graph in terms of relevancy, only 14%, the central bank digital currency, and then blockchain technology and DeFi, big data, and we can see here 72% of relevance for the artificial intelligence in finance sector. And this data was taken from the roadmap of roadmap for the development and reinforcement of financial technology sectors. And we can see as well from this data that I think AI has becoming more and more relevant in all sectors, especially in the private sectors, for the development of one of the most used technology in today's world. Okay, next, yeah. Okay, next, I will talk about the challenge of AI use and compliance to data protection law. So I am trying to see a comprehensive legislations in the Indonesian context, which is from the PDP law and also from the General Data Protection Regulation, or GDPR. Well, the first one is on the AI-based decision-making and individual rights. We see that both Article 71 of the GDPR and also Article 10 of the PDP law, it mentions and also focuses that personal data subjects shall have the right to object to decision based solely on automated processing, including profiling, which produce legal effects or have significant impact on the personal data subject. Meaning that, the data, if the data subjects understand and aware that their data was being processed automatically, solely on an automatic processing without involving any human being, they can have an objections to the result of the data processing. And this is actually a code by the Article 71 of the GDPR, which has the same provisions. And then the second one is on the algorithm transparency and data access rights. Both legislations here mention that actually transparency is at the heart of the data access rights, meaning that personal data processing involving data from the users should be carried out and answering the data subject that they must be aware of what kind of personal data being processed and how the personal data is processed. And if there are any information and communication relating to the processing of such personal data, is easily accessible and understandable, meaning that this is going back to the first principle of data processing, which is giving a clear and explicit consent from the user itself to the data processor. Okay, and the next one is data limitation principle in data processing. So this is because we have the Brazil effect actually in Indonesia. So whenever at the EU they have a new regulation and new legislation concerning a new emerging technology, usually 2 or 3 years later we will have the similar or echoing legislation like the GDPR, and then we have PDP. And in EU they already have the Artificial Intelligence Act, and now we just have to wait. But this course is actually giving a perspective on how do we actually need that kind of our formal legislations on AI, or the soft law in the form of a circular letter is now enough to accommodate the interests of all the stakeholders concerning artificial intelligence and also implementing in artificial intelligence, not just in the public sector, but also in the private sectors. Right. So for the data limitation principle in data processing, the purpose is to limit access and processing of irrelevant data. So in the old days before the PDP law, we tend to give all the data, as Dr. Jefferson mentioned, that in Indonesia, we are a communal country in which we are very easy in giving our personal data to others, especially if, that it is a transaction based. Usually at the supermarket, when the seller asks for our personal data, name, address, and then the phone number, we will easily give in exchange of a discount. So that is a very Indonesian way. Even at the warung or at the food stall, the small food stall in Indonesia, sometimes we also found that our personal data has been printed and used for something else. So we need to understand why personal data is not a big thing in the past, because we are a communal country, we share to each other, we have this royong as our country's value. So probably looking back, it is very hard to increase awareness in keeping privacy as well as the personal data to Indonesians. But now the awareness is increased, and I think we need also to do a constant socializations, not not only depending to the public sector, but also need to have a collaborations with the private sector and also higher education institutions to increase the awareness. And the other point for the challenge of AI use and compliance to data is the data security and storage. And in both Article 5 GDPR and also Article 16 of the PDP law require adequate data security protection. This is because AI, they can handle massive amount of data. And we believe that companies and personal data controllers, they must implement strict security measure, and this has been mandated into the PDP law, and it is already fully enforceable since the 17th of October 2024. However, now a lot of private sectors, non-state actors, they are still in the process of compliance to how to say it, to enhance the security measure and then the compliance to the PDP law itself, including the explicit consent and so on and so forth. Right. And then the third point in my presentation is that about company responsibilities in using AI to process personal data. If we talk about this compliance and also responsibility of company, in using AI, companies or private sectors, they are required to comply with the basic principle of personal data processing, of course, as regulated in the Article 16, paragraph 2 of the PDP law. And additionally, Bapak Ibu, ladies and gentlemen, in Indonesia, AI has not been explicitly recognized as a legal subject or legal entity. And as in many other countries, responsibility for AI action will fall on the individual or entity operating the AI. So it must be the operator or the managers who give the prompt to the AI, and then they have to take the responsibility for whatever consequences AI has been resulting. And responsibility for all AI decision lies with the personal data controller itself. The data subject, manager, or a controller, as well as processor, they have the role to determine the goals, the need, and even AI system in using personal data. So all AI and system decision will carry out these orders and are accountable to the manager. And if we look at into the Civil Code of Indonesia, or in the Indonesian Civil Code, KUH Perdata, the Civil Code indirectly provides options that AI can be analogized as a worker. So these are the two perspectives that I give. The first one is AI can be considered as a worker. And this can be seen in the relationship between worker and also employers as regulated in Article 1367, paragraph 1 and 3 of the Civil Code. And based on these regulations, we can analogize AI as a worker by looking at the characteristic of the worker inherent in the AI system. So this is actually following the international system of, if there is something new, there is a, what is it called? Like something or contemporary or a new emerging technology that is new to the field, how the legislation trying to catch up with the technology is that using the principle of same risk, same activity, and same regulatory framework. So in this sense, when we analogize AI as a worker, then we can refer to Article 1367 So meaning that the legal relationship between AI and also the manager or the one who input the prompt is as a worker and also employer. However, if we take this perspective, it should be remembered that if AI is a worker, it has also a legal relationship with the employer itself. Of course, AI is also responsible to the employer if AI breaks the law. However, in this sense, it is very hard to ask for responsibility for the AI because when they are held responsible independently, they cannot be held accountable because it has no consciousness. So unless or until AI has consciousness, we could take the stand and analogize AI as a worker. But since it cannot, then I think I will move on the second perspective in which more relevant, where we see AI as an electronic agent. AI can also be identified as electronic agent as regulated in Article 1, number 8 of the IET law. It mentioned that electronic agent is a device of an electronic system made to automatically perform an action on certain electronic information organized by a person. So we see that in this sense, or in this perspective, AI is considered as electronic agent. And I think this is resonates well with the IET law and also the government regulations number 71 of 2019 concerning the implementation of electronic system, which states that the electronic service providers or PSE is a legal subject in carrying out the legal responsibilities and action. And if conducted by electronic agent, all legal consequences in the electronic transaction shall be the responsibility of the electronic agent organizer, meaning the one who can be held responsible is the electronic agent organizer or electronic agent provider. We call it PSA, Bapak Ibu, penyelenggara sistem elektronik. So this is more relevant, and I think this is more makes sense that if we see AI as, have the worker-employer relationship within the field of civil law. And since AI cannot be responsible for itself because it cannot be classified as a legal entity in Indonesia or legal subject in Indonesia, therefore, the responsibility of processing personal data is borne by the company or the private entities as the processor or the controller of the personal data. Take the case of the banks, the banks or the financial sectors industry that processes users' data, meaning that if they use the consumer data and process the consumer data for any kind of decision, then they can be held responsible. However, if we look back and if we refer to the Article 10 of the PDP law, the subject of the data itself or the users in this case, we have the rights to object any kind of consequences that AI made without any involvement of human being. And in this sense, I would conclude that this is actually in line with the concept of vicarious liability, where the party that uses or develops AI is responsible for errors that may be made by the system. So not the AI, but the manager or the, the operator of the AI can be held responsible. Yeah. Okay. Do I still have time? Okay, please remind me. Okay, and this is the continuation of the previous slides on the responsibilities in automated decision making. This is the one that I mentioned. In the context of GDPR as well as the PDP law, the responsibilities of companies in this context include two important things. So consumers have the right to reject decision or the right to object to the decisions that are entirely taken by AI without any human intervention. And then second one, obligation to provide adequate explanations. This is also mandated by the PDP law, meaning that if you process data from the user, you must at least in a simple way, in a simple language that every person can understand, you need to explain the logic behind the decision, especially if the decision has a significant impact on the customer itself. Okay, and Bapak Ibu, this is the last point of my presentations on the consideration to ensure AI use complies with PDP legislation. The first one is, of course, obtaining valid consent for automatic data processing involving AI. So the private sectors, in this case, the operators or manager or the processors of data, they need to explain the purpose of using AI in a very easy way or in a plain language, and explain the potential impact of the processed data using AI. And this include the consent from the consumer or the user, you know, on the type of data that is being processed, the objective of data processing, and to what extent the data is being processed, and you know, the other rights that is mandated by Article 16 of the PDP law, including where there are errors in the data, how the subject of the data could revise the data. So that must be ensured and also presented to the users in the platform, application, or whatsoever that uses and also process data from the users. And then the second one is ensuring the security of personal data in AI system. This goes without saying, as theoretically and also beautifully explained by Dr. Jefferson. Data security and also the security of the cyber realm must be ensured in the first place if we want to implement any new type of emerging technologies within the digital era. And then fulfilling the rights of data subject to personal data, because the PDP law guarantees the rights of individuals to their personal data, such as the rights to access, correct, and then delete data. All the private companies and all the non-state actors, they must ensure as well to give access for the user to do these rights. Okay, and the other one is transparency and supervisions. Yes, openness, we need to ensure openness and also transparency of information, including how the data is used, how the data is being processed, and how long the data retention will be safe in the data processor and also managers. And in this case, openness of information on all users of AI in the private sector is also an important thing that needs to be emphasized. And the development of an actionable regulatory framework, this is going back to the first slide, and also something to think about whether the circular letter is now enough. We just need to wait and see on the development of AI and then regulate it later on. Or we can actually, Bapak Ibu, see the sectoral regulations on AI, meaning that if there are consequences with regards to the AI use in the field of copyrights, we could revert to the copyrights law. If there are consequences of using AI from the consumer and also data protection law, we could refer to the PDP law, and so on and so forth. So whether this is enough or not, because heavily regulated technology could impede the development and also the growth of the innovation itself. So we need to strike a balance, as I mentioned. And the last one is this, Bapak Ibu. Okay, wait a second. I don't know why I cannot go back to the slide and click next. Oh, research and educations. Yes, this is actually an open call for all academias and also to the professors to have a collaboration with the private sectors. Because why? Because in order to make an actionable regulatory framework, we need to collaborate with other stakeholders in the digital era. So regulation must be made relevant, of course, and actionable to the dynamic of the very rapid development of AI. And I think research studies, a multiple HALIC collaboration with the industries, with the state, with NGO, with the government, be it the local and the national government, is very important to formulate academic manuscript, advocacy paper as the basis of the development of regulation itself. And the last but not least is, of course, collaborations between actors in the AI ecosystem to raise awareness of the AI itself as an emerging technology, and also the data protection and privacy in Indonesia. This is something that needs to be done constantly and also continuously in Indonesia. As I mentioned, the nature of privacy in Indonesia is different with the nature of privacy in the Western world. we are used to share everything on the social media, on the because between friends, sometimes when we open a discussion, we ask something that is considered as a specific what is it called, data for somebody. We ask for the address, the name, the age. That is something common in Indonesia, but there is something that is very uncommon in the Western world because it can be considered as a violation of privacy. Right. Okay. Last but not least, this is a call for a paper. I need 1 minute because what I talk about is about the AI transformation and also AI regulations and compliance with the PDP law. And next year, we will be having the first, not actually, this is the third Journal of Central Banking Law and Institutions international call for the paper and international conference with the topic of AI transformations of the financial sectors. And this is a call for all of you. If you are interested in writing about AI transformation in financial sector, you are welcome to write a paper and join the conference. So thank you so much. And I'm ready to discuss with all of you about artificial intelligence and the development of legislation in the digital era. Over to you, Ibu Indirani. Thank you so much.
Thank you, Miss Alfatika. Let's give applause to Miss Alfatika. Yeah, I think we agree that Miss Alfatika gave presentation that skillfully combines theoretical insight and practical relevance, offering a comprehensive framework for addressing AI compliance challenges. The presentation examines Indonesian regulatory developments in addressing the balance between technological innovation and the protection of citizens' rights, particularly focusing on artificial intelligence in the financial sectors. Well, while AI technology continues to advance, Indonesia currently lacks of comprehensive regulation to guide its use, leading to challenges in ensuring compliance with the Personal Data Protection or PDP law. And to address these challenges, Alfatika proposed collaboration among stakeholders, including academia, regulatory bodies, and fintech association. Transparency and actionable regulatory framework are emphasized to guide ethical AI use. And last but not least, I think we agree that her emphasis on collaboration, actionable regulation, and ethical consideration reflects a profound understanding of the complexities surrounding AI governance. This thoughtful approach underscores her expertise and dedication to fostering responsible AI in Indonesia. So it's very happy for us to discuss with her. And for now, we have about maybe 40 to 50 minutes to have discussion in question and answer session. So I will take 3 questions for this round, both from online and offline participants. Please. Yes. 1. And is there any participants in Zoom that want to ask or discuss about something? You may raise your hand. Patrio, second, and okay. We already have 3 participants who will give their comments or questions, please. Please mention your name.
Okay, thank you. My name is Rosie Beni from Faculty of Law, Universitas Indonesia. My question for Pak Jeb dan Bu Atika ya, Bu Atika. The simple question, I think. What is your opinion regarding the implementation of PDP law in Indonesia amidst, as I mentioned, Dr. Jeb and Bu Atika, that Indonesian culture have openness culture in the one hand, but in other hand, Indonesian culture have like a high level or certain level about kejulitan dan kekepoan gitu. Thank you. How about the PDP law in Indonesia in amidst openness people, but in the same time we have culture curiosity maybe or tingkat kekepoan yang sangat tinggi.
Over curiosity.
Yeah, over curiosity. Thank you.
Thank you for your questions. And I will take the second question for Pak Theo.
Thank you, the speakers, for very interesting presentation this afternoon. There are several issues that I want to raise regarding to protection of personal data atau PDP. There is one provision related to PDP law, which is the forming of PDP protection agency or badan perlindungan or lembaga perlindungan data pribadi. I think this is actually the momentum for the implementation of effective PDP law. And we need to give attention for the process. I'm a bit afraid that this will be a delay on the forming of the agency because of the change of the nomenclature of the ministry from Kominfo to Komdigi. But this is also a momentum when the government changed the name of the ministry to Komdigi. Actually, they give more attention to the AI issue. So one other issue that I think we need also to give attention in the future is we need to have an international framework on artificial intelligence, at least at the ASEAN region level. We need that because this is really, this will influence the economic activity and trade activities, and also at the same time, the issue of legal responsibility and other related consumer protection, also all those related issues will raise in the near future. That's why we need regional or international framework on this issue. So this is actually not a question, but it's more like a thought that I want to share to add to the wonderful presentation of the speakers. Thank you, sir. Thank you, ma'am. My name is Theo Litai from Faculty of Law of Satya Wacana. Thank you, ma'am.
Thank you, Mr. Theo. And we go to the third participants.
Okay, thank you for opportunity. My name Indah. I'm from Universitas Trunojoyo Madura. About PDP law already the other asking. I just want to know what the two speaker opinion about case PDN Pusat Data Nasional scandal when hacker success to break our national cyber protection. Thank you.
Thank you, Ms. Indah. So we have 3 questions, and I will give opportunity for Mr. Okay, ladies first. So Ms. Alfatika first.
Okay.
Yeah, please answer the question, Ms. Alfatika.
Thank you so much. So I have gathered, questions from the three wonderful participants. The first one is from the gentleman from UI. Thank you so much. And I think we need to increase and also to constantly and continuously do a socialization on the awareness of data protection and privacy. Why? Because I think, in my personal opinion, and also based on the fact and the data, sometimes the consequences of data leakage are felt not immediately, but 5 or 10 years from now. We never know. That's why when we remember that there is a Facebook data leakage, the PDN leakage, and then the e-health, what is it called? The application to check in and check out during the COVID, I forgot the name, is also leaked. Why? Because we don't think there is a damage right now, but maybe 5 or 10 years from now, our data, our personal data are being used to, you know, are being used for a fraud activity or for a criminal activity. So I think what we can do right now is to increase the awareness and the importance of storing personal data and filtering the share of personal data on the social media, on the, you know, stranger, somebody that we don't know. And also, I think the initiative could be started not only at the higher education level, but starting from the elementary level. And it takes a village to do so. And it takes, you know, not just a one-time socialization. It needs to be, you know, like a regular agenda. So I think this is a call for all academicians, practitioners, and also public sectors. We could also invite Komdigi to do this kind of campaign, starting from the elementary school, middle school, college, and then higher educations, to start to do the initiative. Otherwise, we wouldn't be aware and we wouldn't, you know, feel the importance of storing personal data in Indonesia. And for Pak Theo, thank you so much from UKSW. I echo your arguments that the formation of the PDP agency is urgent because I believe that from the PDP law, it says that it will be mandated by the presidential regulation. However, up until now, the status is still coming soon. And I'm also looking forward to actually know the data protection agency because I believe that they have a very strategic and important role in the implementation of data protection and also privacy implementation in the digital era. They can supervise and also they can supervise the formulation of policies and strategies, and also they could impose sanctions mandated by the PDP law, and also for the non-compliance of the PDP law. And the most important one is they have the capacity to facilitate alternative dispute resolutions. Before PDP agency exists, we are now confused. Where should we go if there is a non-compliance to PDP? If there is a data leakage, who should we go to? So I think this must be put on the top of priority in order to for us to make the PDP law as the actionable law in Indonesia. So yeah, let's wait for the development of PDP agency, Pak Theo. And let's see, but probably next year because we have a new cabinet. Hopefully they will put this as a priority. And Ibu Indah from Universitas Notohamidjojo Madura, thank you so much. You came along the way. I really appreciate that. And with regards to the Pusat Data Nasional or the National Data Center scandal, I think when I deep dive into the story itself, I think it's more on the human resources problem than the data security and also the security system problem, because I heard a story from here and there and also from the data that actually this is not about the security, but this is about a human resources problem in this sense. So I guess in order to have a strong data security system, we need also to upgrade the human resources and also how to say it, like provide a very sufficient and also a good capacity building for the human resources behind the national data center. So I think, as I mentioned, collaboration is the key. When we talk about technology, it's not about the technological aspect, but also the human resource aspect and also the social aspect of technology. Thank you so much. I will hand it over to the moderator. I hope that my answer is sufficient and also could satisfy the question. Thank you.
Thank you, Ms. Alfatika. I think your answer is clear enough. And now we eager to hear what Mr. Jeff will say about the questions.
Thank you, ma'am, Mrs. Indi Wawuran, moderator. And thank you for friends, colleagues who have risen the questions for me. Also, particularly, thank you very much for wonderful, marvelous ideas from Ms. Alfatika before I answer all the questions. First, from gentleman from UI, Universitas Indonesia, Mr. Rossi, if I have not mistaken to catch your name. With regard to implementations of PDP law, yes, we have a cultural problem in Indonesia because our culture is oversharing. Sometimes mothers sharing their babies in the internet. Everybody can see it. This is very dangerous from the perspective of legal regulations or from the perspective of law. So I think I agree with Ms. Alfatika that I think we should make a sort of press program to make sure that our culture is compatible with this legal culture. If not, we will have many problems with regard to the protections of human rights in Indonesia. Particularly now, Mr. Prabowo is very busy with the politics. So, but he has a very big agenda to issue, as Ms. Alfatika said, or Dr. Teolitai said, presidential regulations to make this kind of body, which is a body, a superhero that will protect our data in digital data in the internet. Many countries in Europe has already developed very progressive and dignified rules and regulations in Europe. For example, European Union, this is exactly very strict implementation and developing of the law with regard to the protections of personal data and also the using of AI, including in it. And the second question is from Dr. Teolitai. Yes, we need to have a framework, and I think we should learn the framework from European Union, I think, because they are very progressive in this particular legal framework. So we must learn from them. And also before implementing it in Indonesia, we should filter it with our Pancasila, because we have to make sure, justify the framework from other countries or other legal systems. And Mrs. Indah, Ibu Indah from Notohamidjojo, thank you for PDP law concerning Pusat Data National Scandal. Yes, this is the problem of criminal in data protection law, because as Ms. Alfatika said, there are problem of human resources. Our people who are working in the before DG department that Prabowo made, we have problem there because inside that department there are many people who are using the system to protect the gambling in Indonesia. So it means we have a very big problem. The law is not the problem in Indonesia, but the people. But I think we also have successfully dealing with this, because our legal system, especially the criminal justice system, has already implemented to take responsible or held criminally responsible for those who are responsible, who dealing with the protections of data and also the implementations of regulating the internet in the department before what they call it, digital department, that is now we have a problem with them. But with regard to Pusat Data national scandal, I think the problem is in human resources. I agree with Ms. Alfatika that we need to concentrate on making sure that our people, our apparatus who are working in this department are very, very good, having a very good integrity to handle this particular problem. Thank you.
Thank you, Mr. Jeff. And we continue to the second session of question and answer. I welcome from those in this room and on the Zoom. So please raise your hand. Yeah, anyone want to give a comment or questions about something? Okay.
Thank you, Mrs. Moderator. I would like to respond to Ms. Alfatika concerning the idea that we should use KUH Perdata, our civil law, GDPR, and also PDP law with regard to making the AI as a legal subject. Ms. Alfatika offered Article 1367 1 and 3 of our civil code to solve this problem, but still have another problem following the solutions, that we cannot held responsible if the AI is treated as an employee of us. The problem is, Alfatika, my question is, if you offer this kind of solution, this is very good ideas, but how about the consent that every user of the internet, of the computer, once they enter the computer system, they press enter. It means they agree. They give their consent before they enter the computer systems. So if we try to use the analogy of employer and employee relationship in the Article 1367, but the problem is, can we, for example, because we have already agreed, we have given our consent before we enter the computer system or internet system or the cyber world, it means that if we have already agreed, we have already agreed of everything that will become the result of our agreement. So if we are treated as employer, we will be held responsible criminally and also in the civil court, I think. Mrs. Alfatika, would you mind to comment about this? Thank you.
Thank you so much, Dr. Jefferson. Actually, I offer two perspectives and I agree. this is not the sole solutions to this, problem, which is the category of AI as the legal entity in Indonesia. Because even though we treat AI as a worker, there are still loopholes. First one is, I agree with you, the consent or the what is it called? The agreement clauses of the consent in the electronic transaction is simply a click wrap agreement. So once the consumer click something, meaning that they give the consent. However, after the PDP law, especially with regards to the data processing, if what is it called? Is if a processor or if a application or banking, private sectors, and so on and so forth, they would like to process data and they would like to get data from the users, they have to make a very explicit, not just a click wrap, but very explicit type of consent. And it has to be either written or recorded. So the awareness of the consumer itself when they give consent is increased in this sense. And it is been mandated on the PDP law, as I mentioned, on the Article 23 of the PDP law. And then I think it is more relevant and it more makes sense if we treat AI as the electronic agent, as I mentioned. We could refer to what has been stated in the IAT law on electronic agent on the Article 1, number 8, because when we treat AI as an electronic agent, meaning that electronic agent is operated by the what we call as PSE or penyelenggara sistem elektronik or electronic system providers or organizer. In that sense, according to Article 21, it has also mentioned that if the activities or the activities meaning in the processing data activities is conducted by electronic agent, all legal consequences in the electronic transaction shall be the responsibility of the electronic agent provider or organizer. However, if someone or if any context or phenomena can be proven that the error or the what is it called, the misuse of the electronic system is on the hand of the user, then the user could also be held responsible. And it is also mandated by Article 21 of the IAT law. So I guess it a case per case situation, Dr. Jefferson. And in this sense, I think I agree with you. It will be very, very hard to hold responsible, especially in the field of criminal law, if we treat the relationship as the employee-employer relationship. But it will be more sense if we treat AI as electronic agent, because under the Article 21, we know it is very casuist, it's very case per case basis. We know and we could determine who can be held responsible if something could, have or could produce a result that could provide some kind of damage to somebody. So that's my answer. I hope it is enlightening. If not, that we could actually take this into a paper, Dr. Jefferson, and we could co-author a paper together. I could talk about, the perspective of civil law, and then you could give an input from the criminal law perspective. And I think that would be a good paper.
Thank you,
Thank
Ms.
you.
Alpatika, and it's very interesting topic, I think. And I agree, we have to think about how if we put AI as legal subject, maybe it's we have to put a very strong argument to put AI as legal subject, but maybe it can be fulfilled if we connect with the revolution of AI. We already know that AI have some revolution. First of all, AI with deep learning, and then develop to cognitive AI. Right now it's cognitive AI, and it will develop to human level AI agency. And after that, the evolution will go to superhuman AI. And then the AI will have free will. And if that happens, we may conclude that AI is legal subject. And maybe we do not know how to put the AI responsible for doing something. But if the AI be superhuman and it have free will, so it might happen. we still do not know what our work will be. So let's face together and let's put it in some paper. I agree with you. And for the audience here, anyone want to raise a question or have some comment?
Hello.
Yes.
Hello. I'd like to make one comment. My name is Rahul Basu from India.
Yeah,
Now,
please. Yeah, please.
You see, the problem with terming AI as an agent, it involves the criminal intention has to be there in our law. We call it what we call mens rea. Whereas if AI is just a tool, if it does some criminal activity, we have to attribute mens rea to the person who designed it or who has intentionally put something in. Do you agree? That is my observation.
Thank you. Yeah, is it all? Okay, thank you. Mr. Jeff, you mentioned that mens rea, about mens rea, right?
Thank you, friends from India. This is beautiful question. Wonderful, amazing. You made the issue about mens rea. I think when we give consent, when we enter the internet, we make a mens rea. We maybe trapped into making a mens rea or a guilty mind. For example, if we go to internet and we click pornographic platform, it means that we are making a mens rea. We are implementing our guilty mind. So I think the problem is on us, as Dr. Al-Fatika said. The problem is returned to us. We should be held responsible if something happened. For example, if we downloaded the content, and then after that we distribute the content or share the content to someone, and then someone get the content from us, it will be we will be held responsible because of mens rea. But I agree with you, gentlemen from India. Thank you very much. Sorry, Mr. Rahul. Mr. Rahul, it's fantastic. But in law, we learn about something different from mens rea. There is no need to prove that there is a guilty mind. It is just, I forget the concept of this, but I think there is no need to prove mens rea when we enter the computer or internet, and then after we enter, we created havoc or maybe harm to other people. So I think mens rea in this case is not effective to be used as a tool to solve this problem. Thank you.
Thank you. I'd like to make one more observation.
Mr.
Now, yeah, in the problem of warfare, what is happening now, you see in many countries, we have automatic weapons, guided missiles, which have got some intelligence of their own. Now, if they can distinguish between a harmless target and a military target, it involves some kind of decision making on their part. And if AI is involved, would you say that the mens rea is there? I mean, you have to have intention, criminal intention if it is a criminal act. I think we should be careful of saying whether it's the person who uses it or the person who designs it, because it's like a weapon. It may be a remote weapon, but someone has directed it to do that.
Okay, thank you.
Thank you, Mr. Rahul Basu, for your insightful thought. And I will invite Miss Alexandrina. Miss Alexandrina. Yes, Miss Alexandrina, you may give your question to Mr. Jeff.
Yeah, okay, thank you. My name is Alexandrina Aurea Immaculada Moreira. I am from MBA student DIT in Timor-Leste. I want to ask you, to Dr. Jefferson about the difference between cybercrime that implement in human and also in goods, service, and infrastructure. And can you give some example when implemented is a problem and how to solve it? I think this is my question, and thank you so much.
Thank you, Miss Alexandrina. I will give to Mr. Jeff to answer.
Thank you, Mrs. Moderator, and thank you also for Sabrina. Alexandrina from Timor-Leste. This is a very good question. Well, there is a difference between the intention that we created to harm people, and also we created to harm infrastructure. But all of them are using the same tools, in this case, computer, and using the telecommunication systems. So I think the difference is just on the object that we harm. If we use the computer system to harm people, then it is different from we using the computer system to harm infrastructure. For example, the electronic system to do harm for infrastructure, and also at the same time, simultaneously destroy the people. So I think the problem is the differentiation between harming people and also harming the infrastructure is not clear cut. So that's my answer to your question, a very good question. And I would like to go back to the mens rea. I've just found the institutions of law that we can use to solve the problem of mens rea. If we cannot find the mens rea in the technological system, there is a system of law called strict liability. In strict liability, there is no need for people or for the legal system to prove the intention or the bad intention of someone, of the human being. Once the human touch the system and then creating havoc or harm the third parties, then I think the human being should be held responsible directly without proving the intention or the mens rea of the user. Thank you.
Thank you, Mr. Jeff, for your answer. And we still have about 10 minutes if anyone still want to ask some question. Yeah, please.
Thank you so much. My name is Rizky. I came from Yogyakarta, Universitas Islam Indonesia. So I do not want to asking something, but I would like to discuss rather that this afternoon, this evening discussion is about artificial intelligence that we can consider in the future. It can be something like legal subject or something. Okay. I agree with that, but we have also have any future problems, I think, when we do not serve the procedural law itself. Of course, when we are talking about the procedure of law, both in criminal and private or civil one. For example, in criminal, which court or which jurisdiction that examine the cases is where is the crime scene was happened, and the next in the private one. From the principal actor secutor forum rei, where is the defendant's domicile? That was court who has jurisdiction, or relative competence to examine the cases. Now, I'm eager with the explanation both from Mr. Jefferson and Ms. Fatika. When it conclude when AI with PSE, as Ms. Fatika said, it has any relation, and we can assess it as the legal subject. So can we discuss which court who has any relative competence if there is a harm that felt by AI users, even it is by their concern. That's our discussion this evening. Thank you so much.
Thank you, Mr. Sorry,
Rizky.
Rizky,
Yeah.
from UII.
Yeah.
Yes, I will give. I will give to Ms. Fatika to answer or to give some comment.
Okay. Thank you so much from Yogyakarta. Mas, siapa namanya tadi? Sorry.
Rizky.
Mas Rizky, I hope we can meet in Yogyakarta because I'm from Yogyakarta as well. So the first one, I just would like to add and also comment, a little bit of comment to the previous discourse on the whether I could be held responsible or not. I think for that questions, in accordance to the objective of the criminal law itself, if we talk about criminal law, one of the objective is to provide a deterrent effect for the actors. And I think AI will not feel deterred if it does not have awareness or consciousness, meaning that as long as AI doesn't have any consciousness and also awareness or self-consciousness, then it won't be categorized or it can be treated as a legal entity in Indonesia. And then the second one, with regards to the Actor Sequitur Forum Rei, for the relevance and also the the relevant competence of a forum, I think we need to refer to if in the perspective of civil law, we need to refer back to the agreement that they have when execute an electronic transaction involving AI. So, Mas Rizky, because in the context of Indonesian regulations and IET law, especially in the context of the PDP law itself, when someone executed an electronic transaction using an electronic system, they have to have a contract. And usually with regards to dispute settlement, they will refer on what is stated within the contract. And that is actually in accordance with the principle of Pacta Sunt Servanda, where all the parties bind into the contract are bind with the contract, and they must treat the contract as the law itself. So I think the first thing that we should refer is the contract on the regarding the forum of the dispute settlement. But if that doesn't have any what is it called, agreement or any agreed forum, then I think the principle of international private law or Hukum Perdata International will apply in this case. So that's my small answer for your question. Thank you so much.
Thank you, Ms. Al-Fatika. Pak Jeff will give some.
Okay, with regard to the jurisdictions in criminal aspect, I think Mr. Rizky from UII, if you don't mind, you may consult the Article 2 of the ITA law. It is mentioned there that if harm is done in Indonesia and we use the computer system in Indonesia, the people who should be held responsible is the people who are using the computer system and creating harm in Indonesia. So it means that the jurisdictions is in Pengadilan Negeri or our the lowest court in our legal system with regard to criminal law. If the perpetrator is outside the Indonesian jurisdiction, but the harm is done in Indonesia, this is the problem. But in Article 2, it is clear. Even the perpetrator is in or outside the jurisdictions of Indonesia, he or she can be held responsible in the Indonesian legal system. The problem is who will get the people to bring such a person to Indonesian system and ask accountabilities, criminal accountabilities in the criminal justice system. That's our big problem. But that's a big question and very interesting subject of research. Maybe as Dr. Al-Fatika said, we should collaborate to make a research and write a paper. Thank you.
Thank you, Mr. Jeff. And I'm afraid I cannot open any more question and answer session. So thank you very much for all the participants and of course for the speakers on this question and answer session. So I have to make some conclusion, just a short one. I think both presentations highlight the urgency of adapting Indonesia's legal framework to the challenges posed by digital technologies. Ms. Al-Fatika focused on AI governance, emphasizing corporate compliance with the PDB law and stakeholder collaboration to address ethical issues. Meanwhile, Mr. Jefferson Cameo examines cybercrime law, showcasing its role in upholding justice and protecting human rights in the digital age. A shared theme is the importance of regulatory evolution grounded in Pancasila and dignified justice theory to maintain peace, order, and justice. Despite of that, both presenters advocate for transparent law, stakeholder involvement, and continuous education to respond to rapid technological developments. They also share ideas that we as society have to be less capable and not to overshare to protect ourselves. And for academic perspective, from the academic perspective, I think both the speakers are welcome us to continue the discussion regarding this matter in some paper. Maybe we can do collaboration and Hopefully, this conference gives us much more ideas and open collaboration in further study regarding this matter. So for the conclusion from this session, I have to say that together, the presenter, they present a cohesive vision of legal resilience in the face of digital transformation in order to securing peace, order, and justice. Thank you very much for all the participants and the speakers. I will give the mic back to Master of Ceremony. Thank you.
Okay. Give applause to Mrs. Indirani as our moderator and all our speakers for getting the first session seminar. Thank you very much to Mrs. Indi and the speakers. We invite the speakers and the moderators to return to their seats. The completions of first sessions and seminar has opened our perspective and opened up new insights for all of us. We want to extend our heartfelt thanks to all the speakers in this session. We hope that first seminar session has provided a meaningful for everyone. We invite Professor Umbu to present a placard to the speaker, Dr. Jefferson Cameo. To Professor Umbu and Dr. Jefferson, please come to the stage. And also we will have a documentations. Let's give it up applause. And before we conclude today's sessions, we invite all presenters, all invitations, and all speakers to join us at the photo booth venue to take a photos. After that, we have 1 hour to do a break session. Thank you. The photo booth sections is located in front of this building. Yeah. We really hope that everyone could join the photo booth sessions in front of this building. Thank you very much.
sudah. Sudah, Mary. You know how to halabe, eh? Be. Halabe, both just one be. Niralike. Yeah. Sludge. Then, oh yeah, this one. Yeah. Oh yeah.
And then you just press, I think, just test to the next slide. Yeah.
Yeah.
Just check that you know how to work it. Oh.
Ladies and gentlemen, here we are again in the second sessions of the seminar. I hope you had a good time in the first sessions and break time. Now we will have a session that takes the topic of the role of the states in securing peace, order, and justice. Ladies and gentlemen, please welcome our moderator for second seminar sessions, Mrs. Ninon Melati Yugra, SHMH. So Mrs. Ninon, the floor is yours.
Oke, ya. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, Salam Kebajikan. Good evening, ladies and gentlemen, the participants, and also the presenters, and also our honored guests, our distinguished speakers of the seminar for this session too. So welcome back again to the first Notohamidjojo International Conference. So I hope that you had a good time during the first session and also the break time. So before we commence the second session, allow me to introduce the speakers for this session. So today we have privilege to have three esteemed speakers joining us. The first is Professor Dr. John Braithwaite, PhD, from the Australian National University, who has already joined in Zoom meeting. Yeah, Professor Dr. John Braithwaite, can you hear my voice?
Yes, it's lovely to be here.
Thank you. Thank you, Prof. John. I know that this is like 9 p.m. at your time, so we thank you for your willingness to share your knowledge with us at this time. And the second speaker is Professor M.R. Andri Gunawan Wibisana, SHLLM PhD from Universitas Indonesia. Welcome to our mini Indonesian campus, Pak. And then the third speaker is Aderito de Jesus Suarez, PhD, an independent consultant and researcher and inaugural commissioner for Timor-Leste Anti-Corruption Commissions. Are you already in this meeting, Pak Aderito? All right. Yeah, so for your information that Pak Aderito has already, we had Pak Aderito for guest lecture, maybe for the mid-year this year. So we thank you also for giving us the opportunity again to hear your knowledge. All right, so like the MC said, the theme of this session is the role of the state in securing peace, order, and justice. So let's just start from the first speaker. Our first speaker, Professor Dr. John Braithwaite, PhD, is a distinguished professor from the Australian National University. He completed his doctoral studies in 1977 at the University of Queensland and was awarded the title of Distinguished Professor at Australian National University in 2002. With an illustrious career spanning over 5 decades, he has authored numerous books and articles in the field of criminology starting in 1973. He also has received numerous prestigious awards, including the first, the Michael J. Hindelang Award from the American Society of Criminology in 1991 for his groundbreaking work, Crime, Shame, and Reintegration. And also the Stockholm Prize in Criminology in 2006, and an honorary doctorate from KU Leuven, Belgium in 2008, and the Lifetime Achievement Award from ComplianceNet in 2021. So given his extensive and significant contribution to the field, it is definitely our privilege to have Professor Braithwaite as a speaker in this international conference. So Professor Braithwaite, you have like approximately 20 minutes to deliver your presentations, and the time is yours.
Assalamu alaikum. Thank you for that kind introduction and for inviting me to this important conference. It's an honor to be able to zoom in with you. I'll be talking about fundamental issues about democracy. And after all, Indonesia should be proud of the fact that the most important new democracy on our planet since the end of the Cold War, quite a long period of history really, has been Indonesia, such a big and important country that's becoming such a rich leader among the democracies. That says there's a lot of negative things to say about democracy and the threats to democracy in recent times. All states have become more effective at gaming their democracies, finding ways of pretending to be democratic without being democratic as they say they are. That's true of my own society of Australia, and in your own ways, that's true of Indonesia and all democracies. The separation of powers is perhaps the most central idea in the history of institutional design. Without a workable separation of powers, corruption ultimately sets into every country, destroying human development. Corruption in my own empirical work is also shown to be a cause of wars. Getting the separation of powers right is critical to the conquest of poverty and so many societal ills. The most influential document on the separation of powers is Montesquieu's The Spirit of the Laws, articulating with wonderful clarity the three-way separation of powers between the legislature, the executive government, and the executive, legislature, executive, government, and the judiciary. And these three separations are influential in all societies. In the US Federalist debates that produced the Federalist Papers, how to make the separation of powers work, how to bring the separation of powers to life, really was the central issue in those debates. And all countries were influenced by those great American constitutional debates in the late 1700s. But it's also true that most societies today are still autocracies rather than democracies, but a lot of the autocracies in the world today still pretend to be democracies. They have a judiciary. They pretend that it's an independent judiciary in the separation of powers when it's actually under the control of the executive government. They have a legislature which they pretend to be a freely elected legislature when it's actually a legislature under the command and control of the autocrat. So even for these autocracies, this Montesquieu's theory is influential, if only in terms of the fact that they like to pretend that they're complying with it for reasons of international legitimacy. When you ask autocrats to speak frankly about what they think of a democracy, they do argue for authoritarianism. And one ground they give is the separation of powers is terribly inefficient. To have a judiciary who have to be involved and a legislature that have to be involved is less efficient than just having the executive government having a coherent plan for the society and then executing that coherent plan. That analysis, I think, is wrong. A well-crafted separation of powers makes for more effective government. It's actually enabling of decisiveness. So, part of that critique of inefficiency of separation of powers is, oh, well, the state becomes indecisive because all these other branches have to be involved in decision-making. Not so. A well-crafted separation of powers says, you're responsible for this other institution is responsible for that, the third institution is responsible for somewhere else. That gives clarity in who is enabled and given power to act decisively. So if we think of a simple problem that becomes a complex problem whenever something of this magnitude occurs, if we have a senior judge or a top political leader who's believed in the society to be guilty of a very serious crime, say pedophilia, that can be such a major problem that it's a disruption to effective government. Now, it's not when there's an effective separation of powers, it's not the job of other senior judges to say that this judge should not be investigated, nor is it the job of political leaders. It's the job of an agency called the police to decide whether a prosecution should be, an investigation should be launched, and of the prosecutor to decide whether this is a case which should be moved toward a criminal prosecution. And then ultimately, of course, a fellow judge who is not a close friend of the prosecuted judge will hear the case. So that clarity actually makes government simpler and more efficient. Let the police, let the prosecutor, let the responsible judge get on with their job, and all you others whose responsibility this is not, all you politicians stay out of it, all you other judges stay out of the matter of your fellow judge being called to account in this serious criminal matter. Now, in most democracies, the budget is a responsibility of the executive government. So the executive, the prime minister, the president, and his or her cabinet will decide how much money this agency will get, how much that will get, and it may be approved by the parliament, but there will be a tradition that the legislature, if it is an executive that has the confidence of the parliament, will have their budget approved. That's very much the case in the British Commonwealth democracies, governments like Australia, New Zealand, Canada, Westminster system. But in the United States, it's an example of where you do get inefficiency in the way the separation of powers works in this respect. The budget in the United States is primarily the responsibility of the executive government, but every time a major, budgetary change of significance comes down, you find that whichever political party has the majority in the Congress may block it and make demands that this or that favor should be done for this or that state in order to get the budget through. And this is a problem in terms of the United States, so ironically, being incapable of achieving fiscal restraint when it needs fiscal restraint, because the separation of powers in its constitution is not crafted clearly enough to make the design of the budget a responsibility of the executive government. At least that's my view. But of course, most Americans would disagree with that. But debates about these matters are very important in constitutional design. So the idea of the separation of powers is that each branch is a check and balance on every other branch. But each branch must also have its independence guaranteed by that very multiplicity of checks and balances from other branches. That is, there are actually a variety of institutions within branches as well, audit officers and so on, that are acting as checks and balances on different branches of governance. And that very multiplicity makes accountability effective. What we need to avoid is a situation where one branch dominates so much that it's strong enough to resist accountability from the other branches. When that happens, it's usually the executive branch, of course. It's usually the president or the prime minister that becomes the dominating figure of the government of that country, and the checks and balances from the other branches in the separation of powers become irrelevant. But that's the theory. Lots of checks and balances, and the checks and balances have increased over time as democracies have become more threatened by challenges like corruption, but assuring that the checks and balances are, if you like, diffused and spread around enough so that no single branch can totally dominate every decision that they want to dominate. So this talk is about the challenges that democracies face that I mentioned, more gaming of democratic institutions, more pretending to have a free and fair election, whereas the election is in fact rigged, and the Electoral Commission is a commission that's effectively under the control of the executive government and run by cronies of the executive government who get elected, who they want to get elected. So this talk is about why we might need a fourth branch, why the three branches of the Montesquieu model might not be enough, and that fourth branch I'll describe as an integrity and accountability branch of governance that's independent of Montesquieu's other three branches. Now, one of the things that the existing constitutional order of three branches of governance that we all inherit from the Western governments at the center of world power is impeachment. So South Korea at the moment, South Korea, perhaps second only to Indonesia in its importance as a country that in recent decades has transformed into becoming a democracy, and a very rich democracy for all of that. So we've had this scenario of the president declaring martial law in recent times. We've had the debacle of the defense minister who the president ordered to execute the martial law, even against the elected legislature. Now South Korea is a vibrant democracy. Civil society came out on the streets and was strong, vocal, and that has driven quite a good record of the Korean society compared to my democracy, compared to your democracy, in being able to impeach leaders. So we only have to go back for 5 years or so until the last Korean president was impeached, and it is probably very likely that the current South Korean president will be impeached. But compare South Korea with the United States. We had Bill Clinton, President Bill Clinton, subjected to serious allegations toward a young member of the White House staff, very young member of the White House staff, which was subject to impeachment hearings, but that went nowhere, that were just proceeded on traditional party lines. We had many attempts to impeach President Trump after he was elected in 2016. We had attempts to impeach President Biden. None of these came to anything significant in their impact on the democracies. And indeed, we've seen both President Trump and President Biden get into the business of pardoning their family members, effectively pardoning themselves and pardoning large numbers of their political supporters. So a very unsatisfactory picture in terms of how the separation of power operates there and how the independence of the judiciary to deal with these matters is respected. Israel is another. President Netanyahu has been under a cloud so many times in his extremely long political career. Very serious criminal allegations held over his head. Finally, they come to a head in a situation in which his country is totally embroiled in war, and he's involved day to day in war cabinets, and that's a different kind of unsatisfactoriness and how an impeachment process works. So which democratic society has done best in terms of impeachments? Well, I'm not sure about my facts, but I think that might be Taiwan. In the 30 years since Chiang Kai-shek's martial law regime ended and South Korea and Taiwan moved from being an autocracy to a genuine democracy, during those 30 years, there have been 541 impeachment of senior members of the executive branch, the judiciary, or the legislative branch. And that understates how much action there has been. Most of the cases, the impeachment cases, do not end up being a subject of formal legal determinations that this minister is impeached and is thrown out of office. Rather, they result in a more restorative approach to justice for good government, so that they call it corrective measures are put in place so that this minister is counseled that this kind of behavior is unacceptable. And it is a fourth branch of governance, which they call the control yuan. Yuan means branch of governance in the Chinese discourse of the separation of powers, that do these impeachments. It's not the legislature that does them. It's not the executive government that does the impeachment. It's not the judiciary that does it. It's this fourth accountability and integrity branch. And that's what I want to focus on, what I'm seeing as a Taiwanese achievement in terms of impeachment, which looks a lot better than we have in Australia, than you have in Indonesia, than they have in the United States, than they have in Israel. That independent accountability and integrity branch in Taiwan until 1992 was an elected branch, separately elected from the legislature. Now, the major parties in Taiwan, in fact, have become very concerned because the independence of that branch progressively became more of a threat to the power of the major parties. And so they're very much in the business of saying, we want to become a fully Western society. We don't want to have these Chinese constitutional ideas of a 4-5 branch separation of powers. They also have a 5th branch in their separation of powers, which is an examinations branch, which is a Confucian idea that if you want to become a senior civil servant, you've got to pass an exam. If you want to become a legislator, you've got to pass an exam to show that you know and understand what's required of good legislators. So the major parties in the narratives of the major parties are very much about, oh, we want to become a neoliberal society, more like the West, where everything is constitutionally wonderful, and not like communist China, where everything is awful. Then in 1997, Thailand picked up these Taiwanese ideas, and the Thai People's Constitution of 1997, which was produced by a radically participatory process, also developed a 4th branch, no examination branch in this case, but a 4th branch, which, as in Taiwan, has control of all of the agencies which are major regulators of governance. So one of them is the Anti-Corruption Commission, and I'll be interested to hear what my dear friend Aderito might have to say, as with all of his experience with that kind of how it would work if the commission was not responsible to the executive government, but to the integrity and accountability branch of governance, the audit office, the ombudsman, the electoral commission, all of these agencies, the public service board or the public service commission that regulates the behavior of public servants, and so on. And I'd also be interested in what Professor Andrews' thoughts would be on, there's a debate about whether these accountability integrity branches should also be responsible for the major business regulatory agencies, because that's a source of so much corruption. So is it a good or bad idea, in Professor Andrews' view, to put an environmental agency to some degree, maybe a dotted line accountability to the Accountability and Integrity Commission, and still a solid line to the Minister for the Environment? That all came to an end in Taiwan. It was an elected branch, as in, you were not allowed to be a member of a political party. And also, as in Taiwan, you were only elected for 1 term. So one quite long term usually is the idea for this institution. So you might serve 5, 6, 7 years as an elected member of that branch. Just 1 term, you never stand for re-election. So you never have an interest in doing deals that might allow you to be re-elected, and you never get elected on your basis to your loyalty to a particular political party. But they were elected, and that was reversed in Taiwan in 1992, which was a major step back. And in Thailand in 2006, there was a military coup. And just as the major political parties in Taiwan found the idea of a fourth accountability and integrity branch being a threat to their domination of the state. So the royal family, the king in Thailand, and the military, the very dominant position of the military in Thai society, had a military coup and abolished the People's Constitution. And then in more recent times, we've seen civil societies out on the streets of Thailand saying, we want the People's Constitution to come back into effect. So now we need a major Western society that has a constitutional reform that considers this. Could be Australia, could be the US, or it could be Indonesia, an emergent major power like Indonesia that's so important, such a clear thinker and a leader of the non-aligned movement. There are many players that might do it. But all of this thinking started with the Chinese Republic in 1911. It's actually a very old tradition. And it says something about us in Asia and the Pacific that we're so interested in the thought of the French philosopher Montesquieu, but not in the thought of the Asian philosophers, of whom, for me, Sun Yat-sen, the father of the Chinese Republic of 1911, long before the Communist Party was elected in 1949. He, in designing his constitution, visited the United States to learn about US democracy, but he thought it was too populist. He thought people were appealing to the crowd too much and not to expertise and competence enough. And that's why he thought the old Chinese institution that goes back to actually before Confucius of having a control yuan was a good practice to return to in the Chinese Republic. Now, there are many criticisms of Sun Yat-sen. I don't have time to talk about them, but for me, he's one of my intellectual heroes, and it's a great tragedy of in the history of democracy. Sun Yat-sen hoped that Western governments, particularly the United States and the United Kingdom, would support his Chinese Republic, would back his Republican solution to the fragmentation of China by warlords and drug lords at the beginning of the 20th century. But the tragedy was that Western bankers thought that it was true that Sun Yat-sen wanted a strong state, strong markets, and strong democratic civil society. And they liked the strong markets part, but the banks in Hong Kong actually launched a military campaign against Sun Yat-sen and his bankers. And after they captured his party office, burnt all of his manuscripts laying out the philosophy of the Chinese Republic as he conceived it. So I'd like our philosophers in our hemisphere to take Dr. Sun's thought more seriously in the International Academy, in the hope that perhaps in some future moment of crisis, there will be another opportunity for something like the People's Constitution of Thailand of 1997. And I look forward to critical responses on those ideas. Thank you.
All right. Thank you, Prof. John Braithwaite, for your valuable insights on seeing how the separations of powers and also the democracy principle should be implemented in and also significant in countries. And you already began the explanation with the principle of power that aims to design the structure and functions of each branches, and also you stress the clarity of the separations of power that will make government will works effectively. And from the Prof. John's Braithwaite explanation, we can make a summary that we still have challenge with the democracy. And as we know that democracy should be implemented properly. And thanks to Prof. John Braithwaite for explaining to us about and enriching the material with the example of states like US, what happened and what designed in US, Taiwan, and also South Korea and Thailand. I think it has enriched our knowledge widely. So thank you, Professor Braithwaite, for your explanations. And should we go to the next speaker? Yeah. So our second speaker is Professor M.R. Andri Gunawan Wibisana, SHLLM PhD, from Universitas Indonesia. He specializes in environmental law and serves as the chair of the Indonesian Environmental Law Trustees Association. He completed his doctoral studies at Maastricht University. I hope that I didn't mispronounce this university. Maastricht University, the Netherlands, and was awarded the title of professor on April 10 in 20. All right. With 16 internationally accredited articles and over 16 nationally accredited publications, Professor Wibisana is a highly respected authority in his field. So, Professor Wibisana, you have 20 minutes to deliver your presentations, and the floor is yours.
Okay, good evening, everyone. Okay, I'm still waiting for the presentation. So, my presentation, yeah. So I'm really glad to come here and to see all of you guys, and also to share the panel with Professor Braithwaite. So Professor Braithwaite, so John, I use your title, your book title, responsive regulation, but I add unresponsive regulation to solve the Indonesian regulatory schemes regarding environmental law. So let us begin with some facts about pollution in Indonesia. Next. So this is the news about the Citarum River in West Java, which in 2013 was declared one of the most polluted river in the world. So although we should note that the river suffers from solid waste and domestic sewage, a documentary from Deutsche Welle highlights that a significant, if not the most critical source of pollution, comes from thousands of factories dumping their waste into the river and its tributaries. So this is the result. So it becomes one of the most, if not the most polluted river in the world. What about air pollution? Next. So also, a couple of years ago, Jakarta was also listed as one of cities with the worst air pollution in the world. So we have quite good ranking achievement in the world, right? So we are bad in sport, but in pollution we are good one. I mean, achievement. What an achievement. So and next, This is the picture I take from BBC Indonesia, picturing the destruction, environmental destruction from nickel mine in Konawe Utara in Sulawesi. So you can see the result of the mining operation there. So we have to be proud of, proud, quote unquote. Next slide, with this situation. We even exported air pollution to our neighboring countries, right? So that these pictures portray environmental condition in Indonesia, not a good one, of course. And it shows more than just for me, more than just bad environmental situation, but also it reveals a truly discouraging reality for us as legal scholars. Namely, that this is not just pollution. This is the symbol of the paralysis of law in general and environmental law in particular. We have not functioning environmental law. So why not functioning? Because we have actually, theoretically, we have recognition about environmental rights, even in our constitution. Strong, very strong message for the government, actually. And we have very strong environmental law of number 32 of 2009, which not only provides citizens with various protection, legal protection, but also instruments that can be used, sanctions that can be used by law enforcers, the government. So, however, the legal recognition of environmental rights and also our environmental good provisions in environmental law does not necessarily lead to better environmental protection in reality, right? So this is the result. So next. Okay. We have now the omnibus law that amended the our environmental law 2009. Of course, there are regression in some provision, but I'm not going to talk about that. We can focus on the government gesture, focusing on the so-called the use of criminal sanction as ultimum remedium, right? We have ever heard about this many times, that criminal sanctions should not be used in a first instance. Instead, it can be used as only as a last resort. So we have to rely more on administrative sanction. But we have to understand how the administrative sanctions in Indonesia works so far. So next. Wait, I think back. Sorry. So here, we can see here that according to the law, and to the practice, the majority of sanctions, a significant portion of sanctions, of administrative sanctions, are in the form of warnings and government orders. Government, we call it paksaan pemerintah, government coercive order, right? So that two types of sanctions that typically used by the law enforcer, the government. Next, here is an example of a typical government's order. The case was a power plant that violated several obligations, including failure to control air pollution, failure to conduct air emission monitoring, and dumping toxic waste illegally without permit. And this is a power plant owned by our state-owned electricity company, by the way. And also, they fail to manage toxic substances and waste properly. Very serious one, especially the last one, illegal disposal of toxic waste. Next. This is the sanction. I will translate next. So the orders, what are the orders for that violations? Carrying out revision of environmental permit, undertaking restoration in 5 contaminated locations, repairing emission stack emergency diesel, obtaining a permit for hazardous toxic waste. Number 4 is interesting. I will discuss later. Measuring emissions from stationary sources, labeling waste and toxic waste labels with toxic waste labels, and conducting soil sampling for fertility testing and groundwater quality checking. So you can see here, there is no punishment in the orders. So if you own companies and you violate several laws, don't worry, you will not be punished, right? There is no punishment here. Even if you don't have a permit, and to have the permit, you have to meet certain criteria, right? Requirements, and you have to pay for that. And if you don't have permits and you are caught by the law enforcer that you don't have permits in disposal, the worst thing that can happen to you is that you are ordered to have a permit. Come on. Is that punishment? Of course not. If I were a company, if I own a company, I will prefer to violate the law in the first place, right? So with this kind of sanction. So the sanction stated that there will be escalation. So I think this is in theory. In theory, it is quite good with, quite similar with Professor Braithwaite's book, but the pyramid of sanctions.
Aku sampai udah pegang.
That the sanctions should escalate, right? Starting from warning and then until revocation of sanction as the Apindo, a company that accused of creating mud volcano, right, in East Java, was ranked with blue, comply with the regulation. Of course, people will say, how come? But I don't know. But that's not the focus. The focus is number one. Number two, the lack of government responses. I can give the example for this. I mean, the lack of the government responses for the companies with poor performance. Next. So next, yeah, let's start with some data here. I conducted long time ago. This is just the data that I have at the time. Out of 79 firms that received black in the period from 2011 to 2012, there were 32 firms that already received red and 1 firm got blue rating in the previous period. So 37 firms declined from blue to red and 1 from blue to black. In addition, as many as 131 firms have shown non-compliance in 2 consecutive years. What does it mean? It means that the companies do not have incentive to get better. So if once they get red, they have the tendency to stay there. So the improvement is not something they can achieve. Next. This is the data from 2016 to 2018. Also shows that 121 out of 284 companies marked in red in 2016 had remained in the red for 2 or more consecutive years. So you got red this year and then red next year and then red next year. So they will stay there. Again, next. This is hotel. Hotel is very interesting, right? So some hotels are also participated in this rating programs. Why hotel is interesting? You know, if you stay at a hotel, usually hotel try to impress us with their environmental awareness, right? So this is very interesting. Wait. From 82 hotels received red in 2015, 43 of them were already ranked red in the previous year. And 25 of them ranked in 3 consecutive years. Again, hotels are not interested, even hotels are not interested in, because this is majority, right? 53%. The majority of the hotels that get red in the previous year, they will still in the same location, in the same rating. For unknown reasons, in 2016, the Ministry of the Environment and Forestry stopped reporting the proper rankings for hotels. I don't know why. But then it appeared in 2021 proper. So before I continue, I believe that if you know that one hotel that you would like to stay get black, right? I believe that you would prefer choosing other hotels, right? Am I right or not? I mean, I'm not talking, because here I'm not talking about cheap hotel. I'm told these are hotels with 4 or 5 stars. Even some of them with price per night more than $1,000 US. You know, this is not cheap hotel. This is very, very famous hotel, international chains hotel. So next, this is what I got from, because they started again in 2021. So I got 3 consecutive years now. So I see in 2023, I have 55 hotels with red, and 41 of them, 75%, already red in 2022, and 35, meaning 31%, already red in 2021. So very, very, very I mean, a clear picture that something wrong with this. So there is also 11 number of non-available data. There is no data. Sometimes you don't see a particular hotel or particular company in 1 year after they get red in 1 year, and then the next year just disappear. And next year, the following years, it come again with red. So why there are some data that are missing? I thought it is not, I mean, it's not intentional. But next, we can see that apparently, next. Next. So we can see that apparently the number of missing data is actually intentional. I will come back later. But come back please with the number of law enforcement, the previous one, this one. This explains why companies are not interested in improving their poor quality, because the number of law enforcement is very low. This is law enforcement related to the red and black colors. So very, very, very low. So it means that indicating that negative result of proper rarely gave rise to meaningful legal consequences for the companies. And next. So the government did nothing. Actually, they are reluctant to enforce the law because this is voluntary, this is not command and control, something like that. This is an alternative for command and control. So next. So this is what the government, because if we cannot rely on the government, we can rely on the market or society, right? We can, I believe that, as I said before, if you know that a hotel with red and black, you will not choose that hotel to stay, right? Rather to pick blue or green. I believe so. And it is interesting because the government, it seems to be interested only in showing and make an announcing firms with good performance. So they will celebrating companies with green and gold colors in a fancy hotel usually. But then but for hotels or companies with poor performance, they will just put under the rug. So you won't see it unless you do it a research like me. So so there's a let me give an example of an irony. This is true. This is true. It's just happening to be. So already in 2 weeks, the Indonesian until now, the Indonesian Supreme Court conducting a certification training for environmental judges in Indonesia until now. So this is, I think, the last day. The training is held in a 4 or 5, I don't know, but 4 or 5 star hotel in Jakarta. Guess what? The hotel has been rated red for 3 consecutive years. You know, why we pick that? Why the Supreme Court picked that hotel? Because they don't know. They don't know about this one, right? So this is irony. I was once also discussed about the curriculum of environmental law in one hotel, and I realized later on that the hotel was red. Because we don't know about this if we don't check in the website. So this is interesting, because then it seems that for me the government only interested in informing good one, but keep the public uninformed about the improvement, about the bad performance, about the companies with bad performance. Next. So I propose that it can be improved actually by making it mandatory disclosure with instrument combined with the command and control instruments sanctions, or voluntary instruments with command and control based instruments, and mandatory participation, and awards for compliance rating, blue and beyond compliance, and escalating sanction on the other hand, escalating sanction for non-compliance rating, red and black, something that are missing until now. I come back. This is the last slide, I think. Now, next. This is the last slide. No, next. Yeah. So I come with the several easy ways for hotels, and it could be done just like that. The government's responses do not have to be in the form of sanctions, administrative or criminal. So it doesn't have to be sanctions. It could take the form of shaming and naming. And I think shaming and naming could be very, very effective for hotels. So, and it's very easy. Because why? Because if we are as customers are well informed, we can do something about it. As I said before, we can choose hotels we avoid choosing hotels with red and black, right? And prefers other one. So, but we should know about this one. Now we can only know if we dig into the website of the minister and check one by one. That's time consuming, and I think none of us, I mean, not all of us are interested in doing so unless you are doing research on that. So my proposal is the government can cooperate with travel agencies and put these red, black colors. So if you check, for example, in the application of agencies, and you try to find a hotel, and you can see that the hotel is red or black, you can avoid. You have the choice to avoid that hotel. At least you have the information about that, and then the choice is yours. But until now, that's still far from reality. So with that, I conclude my presentation. Thank you very much.
All right. Thank you, Professor Andri, for your comprehensive explanation, specifically in environmental law. So your explanation highlighting the setbacks from the 2023 Omnibus Law on Job Creation, and you focus on the reduced public participation and also ambiguous sanction and the criminalization of certain environmental offenses. And also we can see from his materials that he explained about the proper program. Yeah, I believe that none of you have ever heard about this, and also I do. All right. Almost 30 years, and it has existed for like for a long time, and we just have heard this from this event. All right, so you concern on the proper program. Well, initially innovative, it faces issues of credibility due to self-report data and the others, and also you stressing that your material suggests that to enhance transparency, enforcing sanction for poor performers, you suggest the sanction like shaming and naming, yeah, just like what he explained from the last part. All right, so thank you, Professor Andri, for your materials. Now we come to the final speaker for this session, Pak Aderito de Jesus Suarez, PhD. Yeah, I will read first his CV. So, Pak Aderito de Jesus Suarez, PhD, is a distinguished independent consultant, researchers, and the inaugural commissioner for Timor-Leste Anti-Corruption Commissions. The speaker earned his Bachelor of Law degree from Universitas Kristen Satya Wacana and his doctoral degree from the Australian National University. His research examines the intersections of international human rights law, governance, and regulatory theory. He brings a wealth of experience, having served as a lawyer and advocacy coordinator at the Institute for Policy Research and Advocacy, ELSAM, in Jakarta, and as the Deputy Chief of Party for the Accountability and Integrity Mechanism Program in Delhi. So, Pak Aderito, you have 20 minutes to deliver your presentation, and the time is yours. Yeah, Pak Aderito, can you hear my voice? Oh, I think you're still muted.
Unmute. Okay.
Yeah.
Can you hear me now?
Yes, we can hear now.
Yes. Thank you and selamat malam to the organizer. I would like first to thank my dear friend Professor Umburauta, the Dean of the Law School, and then also Professor Freddy for extend the invitation to me to deliver this paper, to deliver this talk. And I feel so privileged. I think in June, I was invited first to give kind of a lecture to the students. And I proposed at a time a topic on governance and law. And it was just very broad speech that I gave to the students. And I was so happy to see how Professor Umbu and Professor Freddy and the team put this in a much more structured topic for this today's seminar, today's conference. So I feel very privileged for that to attend this, and also very privileged to share the forum, this session with Professor Andre, and then also my intellectual mentor for many, many years, Professor John Braithwaite. I think we are so lucky to have Professor John Braithwaite, because when I contacted him, actually he replied me through email in Portuguese, and I found out that he was in Brazil for another field research on environmental issues, all this stuff. So we are so privileged to have John, and John such a giant intellectual social scientist that I think myself, I learned a lot from John, and I'll encourage friends in Satyawacana really to go to John's website that they developed by his students. So many materials that are very, very useful for us to see. Anyway, since we are here in Canberra, I think 11 o'clock, 18 past 11 now. So I think I will use maybe 10, 15 minutes. So instead of talking about law and governance that I delivered before, I choose to explore the nexus between corruption, political stability, and peace. So if we can go to the next, the third slide. Hello? Yes, next one. So I'm going to talk about these three topics, but let's just start a bit with the, I bet just to bring us into the same page about corruption, because I'm talking about corruption and conflict. Up until now, there is no common definition of corruption. World Bank came with their own definition as abuse of public power for private benefit. Not much different with in Transparent International, where they define corruption as the abuse of the entrusted power for private gain. And one of the famous formula by Robert Cleargut that I think most of us that involved in the anti-corruption sectors know that, he put this formula: corruption equals to monopoly plus discretion minus accountability. And interestingly, like the United Nations Convention Against Corruption, UNCAC, that was the convention of the UN, they didn't come with the specific notion of definition of anti-corruption. Instead, they identify the type of corruption, like bribery, trading of influence, abuse of function, and all this, foreign and national bribery. So they come with that type of difference, corruption that put in the convention, instead of come with the specific notion or specific definition of corruption. Interestingly, just 6 days ago, on the 9th of December, that is the International Anti-Corruption Day, where many countries commemorate that International Anti-Corruption Day. And it was interesting, like in Myanmar, the general of Myanmar, the general of Tatmadaw, Min Aung Hlaing, he came with kind of, he tried to define what corruption is. And I'll come to that Myanmar later as I move. Let's move to the next PowerPoint. So I think interesting to understand that in the past, the whole discussion of, whether corruption as an impediment to development or economic growth or to democracy, or as lubricant to development. Even someone like Paul Huntington, in the past, in the 60s, when he wrote his book, I think, I quote here, he even think that, in especially in developing countries, corruption can be lubricant to easing the path to modernization. That's what Samuel Huntington says, and of course, some of the commentator those days also, they will argue that, corruption is a greasing to wheels the development of the economy or economic growth. Yeah, and I think the answer should be no. Yeah, corruption should be considered as an impediment to economic development, which violates the basic rights of people, corrupts tax system, corrupts procurement system, which is also can lead to state capture. Let's move to the next one. So interesting to see the development of how corruption and developments intersects. I think in the past, in the 70s and 80s, even World Bank and all, international financial institutions, I think to some extent they ignore the corruption as impediment to development in those era. And eighth sector ignore corruption. Someone like Joseph Hanlon, who is this British academy, who did a lot of research in Africa, mostly specifically in Mozambique. He will come with a very strong argument that because of lack of regulation on corruption, it exacerbates the corruption in those host countries that get the development aid from World Bank or other IFIs. And it is, of course, things turn differently in the 90s, where the notion of good governance and corruption enter into the lexicon of development. And that is like the new era of how to see the intersect between good governance, corruption, and development. Let's move to the next slide, please. So here, I think I'm talking a bit about, especially in the post-conflict society, always the questions about the sequencing, whether you first, especially in a post-conflict society, whether you concentrate first on security and stability or an election as the first priority, or you start to do efforts on combating corruptions. Some author like Dominic Zaum and Christine Chang in their book in 2012, they will say that, fighting corruption is not the only objective of peace-building actors. Not it is the necessary most important one. Enabling corruption might be a price that peace builders have to pay to ensure the participation of warring factors in peace agreement on the large scale of violence. I think that is the word that, once you tackle corruption, especially in the hard way, like, on criminalization, it can be counterproductive to the whole violence, to the whole peace process. And I will argue, of course, some academics also will argue that, I think that process should go hand in hand, and especially, start with prevention and education first before tackling strategies such as criminalization. And I think in these topics, in this argument, I think the work of John Braithwaite on escalating the punitive and preventative and responsive regulation is very relevant. In my own work also, I'll talk a bit like, in my own work where we start, Timor, we start in 2002. In 2002, when we got independence, we said that we restore our independence in 2012, where I have the chance also to be one of the members of the Constituent Assembly to draft the Constitution. We enshrined in the law, we established the not the Anti-Corruption Commission, but we established the Inspector General Office. Yeah, Inspector General Office to do internal inspection to the government. So that was started in 2002. And then by 2006, we established the first, under the Constitution, we established the, what you call as the Human Right Commission, which is to some extent has the power of ombudsman, where Human Rights Commission also, first the mandate is, to promote and defend human rights, but also they have the mandate to investigate or do investigation on good governance and also corruption. And they can report that to the Office of Providor or the Office of Prosecutor. So we start very early, the whole issue of anti-corruption. And it came later on the 2010, where we established the Anti-Corruption Commission, where I had the privilege to start the office from ground zero. And I had a 4-year experience there working and establish the office from zero. But now we have the commission, we have almost 100 staff there, and I'm proud to see that. And in the first 4 years, for example, we managed to tackle some of the very senior minister in one of the most powerful prime minister, Xanana Gusmao, as we all know. He came from the history with such a strong leverage and a strong influence, charisma. But in the 4 years of first period of Anti-Corruption Commission, we brought to justice some of the very big fish of that government. And I have to acknowledge that that was not an easy task. That is always the challenge of tackling corruption especially in small country like Timor. We have 1 million and maybe 200 or 300 people now, population, where everyone know each other. And to be frank with you, I know most of them at the time. Many of them were my friend during the struggle, during the study together. So I have to behave in that way. And I think we made quite good progress. When I started, I think in 2010, the rank of anti-corruption, the CPI, Corruption Perception Index, we are 130, something like that. Now I think we are down to 70. So we are actually, to be frank, we are doing better than Indonesia now. I went to visit the Indonesian Corruption Commission during my time, and we are hosted by the Indonesian President Susilo Bambang Yudhoyono in the palace, with different commissions from Asia Pacific. We have discussion there. But as John mentioned, I think about the separation of power, and one of the argument that John advanced in one of the book that I co-author with my small contribution called Network Governance and Freedom of Peace in Timor-Leste, where we advocate on the separation of power, the continuous improvement of separation of power. And I think there's a challenge of this new country, and I think not only the new country, but also developing and also developed countries. Let's say if we look at the US, of course, we can make all these arguments. Let's go to the next slide, please. Yeah. Yes. So you look at this. I'm talking a bit here about corruption and political stability. So on the slide, the picture there is the picture of General Min Aung Hlaing of Myanmar. He's the dictator now in Myanmar. Have control more than 400 Tatmadaw. It's like the military there. And that was just the photo. This event was taken on December 9, just 6 days ago, as I mentioned before. That was International Anti-Corruption Day. So you see how the general commemorate this International Anti-Corruption Day in Myanmar. And one of the statements that he made here, I quote here, corruption, he said, corruption not only hinders the achievement of national development goals, but also harms the rule of law, peace, and stability. Can you imagine that come from this dictator? And just last year, if I'm mistaken, he got two of his general. I think one of his senior staff, generals, were investigated because of corruption cases. And I think now they are in prison. But the question is this guy act in a genuine way? Or this just he used corruption as a political weapons to attack, to control his enemy within, and also to get the public sympathy after the whole crisis in the last 2 years since the coup. So this is the challenge of corruption. If we don't have good democracy, it can be weaponized to attack your opponents, not only in the government but also civil society at large. While Office of High Commissioner of Human Rights is quite old report, but they say it here. While Myanmar's government has signaled the will to combat illicit financial flows, some of the most powerful vested interests in the country benefit from that. And even the 2 kids of the General Min Aung Hlaing, they got all these lucrative contracts. They have mansions. The generals himself have several mansions in Myanmar. Some of the report of Transparency International can show us about this. So let's see that. I want to say here is corruption really affect the political stability, and this is not only Myanmar. We can go from other countries now. I'm kind of observing one of the former Portuguese colony called Guinea-Bissau, where our current president, he was there as the special envoy of Secretary General of the United Nations, and then Timor also helped that country organize the first democratic election a couple of years ago. But I think because of corruption again, it comes turmoil and all this instability again happening in that country. And I'm kind of doing a bit of research on that for my own purpose. Let's go for the next slide. Hello? Yes, I think this some kind of consequence of corruption that many of us know. Corruption has direct effect on political stability, creates state capture. Corruption erodes public administration and undermines the integrity of institution. Corruption erodes the foundation of democratic principles. John raised that issue before, weakens the governance, enhance clientelism. I think on the clientelism, I think James Scott did quite good research in the 60s and 70s in Asia Pacific, where he talked about how clientelism is very strong, and also in Pacific, in Pacific countries like in PNG, Solomon Island, all these things happen here. We call here in Pacific, they call it anyway. And corruption, political stability, conflict, also corruption, political stability, instability, and conflict are intertwined. So that is very interconnected of this issue. Please go to the next slide. Yeah. So this is the last slide, and I think maybe here maybe not the role of state, but maybe mostly the role of government, because state we're talking about public, we're talking about we all. So I think in this kind of situation, I mean when you talk about conflict and post-conflict society, but just these 2 weeks, just this week we followed the whole issue of the whole saga in Syria. I was just look at that when the media covered the garage of the cars, vehicles of President al-Assad, Bashar al-Assad. My gosh, so many hundreds of fancy cars there you can name, all these fancy cars there. How come, people are living in such a poverty, but this guy living in such a lucrative facilities? So this is the whole issue. If we talk about the intertwine between corruption, conflict, and instability, political instability, is so many cases that we can talk. I don't present any specific case here, but my presentation just really try to give you big picture, and I'm doing my own research on this issue. I think governments should uphold the rule of law, i.e. on ACC, on Anti-Corruption Commission. I think governments should avoid to intervene on the role, on the work of ACC, and I think that's really correlates with the idea of separation of power that John talked about. And you can give we all very familiar. I'm very familiar with KPK, the Indonesian corruption laws in the last few years, where I think they face a lot of intervention. If I'm wrong, please correct me, but I think I follow very closely about that. Likewise, in my own country, in Timor-Leste, also, I think last 4 years, actually, the Anti-Corruption Commission also faced some political intervention, and we are kind of try to advocate for that, and of course, government has to create more space for civic expression, and I think we have to avoid what I call as democracy of an oligarchy, where democracy operates hand in hand with the growing influence of a number of small group of oligarchs, and that is a challenge of many of developing countries. It's happened also in developed countries, but I think they have more stable institution to control that. While in developing countries, we still have this kind of, let alone post-conflict countries, we still have this challenge of unstable state institutions. And of course, the main challenge here is deliver the basic needs of people and share the development cake for everyone. And here we have to tackle corruption if we want to deliver the basic needs of the people. If people want to have, the education or health, they shouldn't bribe officers to do that. And lastly, I think we have to avoid what Lawrence Lessig, I think this is the Harvard professor, came out with the idea of institutional corruption, which is quite interesting to see that. He defined institutional corruption as, where systematic and strategic influence, which legally or even ethically, that undermine institution effectiveness. So you have the systematic and strategic, which is kind of legal and even ethic, were used by the power holders to undermine the effectiveness of state institutions. That is the challenge, and I think happen everywhere. If we talk about how the government tried to weaken the Anti-Corruption Commission, that is exactly what we call, as I think Lawrence Lessig put very clearly, about institutional corruption. And I have to acknowledge that, as someone that works in that area, we face this problem seriously. Sometimes opposition will support us where they are outside if the Anti-Corruption Commission doesn't touch their members, but government will kind of defend themselves. And in my interaction with many anti-corruption commissioner, in Asia Pacific and also Africa and Latin America, we all face this problem. And I think that is really back to John's main thesis on the continuous improvement of separation of power. And it is a challenge for not only post-conflict countries, developing countries, but also developed countries. Thank you so much for that.
Yeah. Okay, thank you for the engaging presentation, Pak Aderito. And from his presentation, we can see that he explores the complex relationship between corruption, political stability, and peace. And also he highlighted its forms such as the bribery and state capture, yeah. And also he also stressed that the corruption is shown to erode democratic principles, weaken state institutions, and contribute to political instability, creating a cycle of conflicts and also poor governance. And also, I think the presentations also calls for a sequence approach to combating corruption, starting with education and prevention before enforcing punitive measures. And I can see that Pak Aderito stressed that the role of the state in ensuring accountability, equitability, development, and preventing what he called democracy, where democracy is dominated by oligarchy influence. So thank you, Pak Aderito, for presenting your materials. And now we will start for the Q&A sessions. We still have like 20 to 25 minutes. So I will take like 3 questions first for the first round. So any of you in the Zoom meeting or maybe in the room, you can ask directly, and please mention to whom the question is addressed to. Okay, I can see from this room, Pak Jeff. Okay, Faki, and yeah, the front one, yeah. Okay, the first one, I will, please, Pak Jeff, yeah.
Thank you, ma'am. Mrs. Moderator, Ms. Ninon. It was interesting to listen to the deliverance from Professor John Brightway. Prof. John, it seems like you are exploring the problem of criminality or crime against democracy using criminological approach, I think, if you wish me to say like that. Please correct me, Prof. I think this criminological analysis on the destruction of democracy as a crime against democracy is the root cause, if I follow your fantastic insights. This is the root cause of environmental destructions, as Professor Andri has already made a very, very complete and fantastic picture of the destruction of environmental in Indonesia. That's the first impact of the destruction of democracy, crimes against democracy, the rule of law, and also other principles of law. And the second destruction, the impact, has also been described by Dr. Aderito. Hello, Aderito. It's nice to see you.
Thanks. Nice to see you, Professor Jeff. Nice to see you.
Okay. You describe the impact of the destructions of democracy by constructing the jigsaw puzzles of destructions of corruption from west to the east and also north to south. It was fantastic. But I would like to have the 3 of you, especially begin from Prof. John, about what I got from the 3 of you. The point is I would like the 3 of you to respond that if we continue to do such things, pretending that we are democracy, pretending that we are the protector of environment, and pretending that we are the anti-corruption countries, if we continue to do such this modus operandi, I think not in a very, very long time, we will see the destruction in Indonesia very soon, I think. So please give me a very good an insight, a philosophical insight about the prediction that maybe Prabowo will face the same problem if this modus operandi, as Professor John said, not only because of the fault in the democracy by Montesquieu, I think, Professor John, I think the problem in Indonesia is because we fail to obey the Pancasila, I think. We all in Indonesia now not fear God anymore, but we say, oh, okay, Pancasila, God Almighty. We don't have human rights. We said humanity in our Pancasila. We don't have unity of human being in Indonesia. We don't have democracy, as Professor John said. This is the root cause of all of the destruction in Indonesia. And the last one is we don't have social justice. So please respond. Please kindly, I ask the three of you to respond this understanding. Maybe I have got something wrong. Thank you very much, Mrs. Moderator.
Thank you, Pak Jeff. So I think this question is for all of the speakers, yeah. Okay, for the second, I see Faki. Yeah.
Okay, thank you, Miss Moderator. My name is Faki. I'm here on behalf of Pusat Kajian Hukum Pidana dan Kriminologi, here with my friend Belby. I would like to ask for Professor Andri Gunawan. It's nice to hear your presentation today because we all discovered new things based on your presentation. My question is, how can these proper program implementations be improved to prevent case like Lapindo, as you say, which despite its major environmental impact still receive a good rating, I think. And the second one is you explain us about shaming and naming applied to the hotels. And I would like to know if this principle also applied to another environmental sector, like maybe air or water pollutions. Kim, Destin, thank you very much.
All right, thank you, Faki. So this question is for Prof. Andrea. Okay, so the last for the first round, please.
Thank you. So first of all, I have to introduce myself. My name is Matthew, and I have one question for each of the speaker. First, for Professor John Brathwaite, I would like to know your opinion for what I call the things that are happening in Indonesia itself. Is I call this buddy politics. Yes, culturally, Indonesia is a very collectivist nation. We are very collective and usually focus on the objective of the group rather than the individual itself. And because of that, it usually in Indonesia right now, what we see, the people really like the idea of our country's leaders, even though in different jurisdiction, for example, the executive, legislature, or the judicial branch get along very well and play buddy politics. So, and because of that, from my opinion, I think it very much blurs the line between the ideas of separation of power between the three institutions of the governments. And because of that, I would like to know your opinion about this. And if it's a huge issue, how do we address this? Now, for the second question for Professor Andri Gunawan, My main thing is about there's a sort of a paradigm in Indonesia, not only in our masyarakat, but also in our government paradigm about thinking about economic development versus environment and sustainability. There's a thinking that we need to prioritize one thing first before the other, and that right now we used to tend to focus on economic development, and because of that cause very much environmental destruction in our own country. I would like to know how do we address this issue. Now, for the last question for Dr. Aderito is about the anti-corruption institution. From what I've known in Indonesia and in the past years, our institution itself, KPK, has, in the eyes of the public, has been compromised by practical politics. And because of that, KPK, which was viewed as the thing that should keep politicians and the political elite in check, is now viewed as an institution that is a part of the political elite itself. And it's not something has now become something that is not technocratic or not professional and plays along with politics in Indonesia. My question is, how do we make sure an anti-corruption institution stays technocratic and stays professional? Thank you.
All right, thank you. Matthew, yeah. Okay, thank you. So, what a bunch of qualified questions here that should be that must be responded by all the speakers. So, for the first opportunity, I would like to please Prof. John Braithwaite to give your response for all of the questions. Yeah, Prof. John. Is he still in the Zoom meeting? Can the committee?
There we are. Yep.
Oh, yeah, okay. Please, Prof. John.
Yeah. I'll start with all the questions. Very good, I must say. I'll start with Matthews on the buddy politics. Of course, buddy politics, buddy society is a good thing. We want to have a relational society, not simply an individualistic society. We need strong individuals, but we also need strong relationships, strong and strong government and strong markets. We need all of these things for society to be effective. So one of the ways I think about this is like with my thinking on responsive regulation, restorative justice has a place there, and it's a kind of form of buddy justice, if you want to put it that way. It's a relational form of justice, and what I advocate for is an informal justice, a relational justice that enables and supports formal independent justice of the judiciary, and a formal justice that enables informal justice, as, for example, when a judge will say, well, I want to defer my sentence until I refer this case to a restorative justice conference. So we want a buddy justice that is conversational, for example, about why corruption is a terrible thing, and restorative justice enables that relational strength of buddy culture to do some of the work of a more building a more just culture. So we can pull these things together with a smart architecture of regulatory governance, I would say. And on Pa Jeff's comment about lip service to Pancachilla and other fundamental values, foundations of the society, we also need to build that in a relational way. And I think restorative justice has a place in that. I think you're right, Professor Jeff, that corruption is a big reason why in all societies environmental regulation does not work as effectively as we would like it to, as we saw in the wonderful presentation we had on that today. Sometimes it's not so much corruption as capture. Like, it's not that anyone's paying a bribe to the environmental regulator. It's that the environmental regulator wants to be friends with powerful business people, wants to be liked by powerful people in the society, and knows that or her political masters want to be loved by powerful business people as well. So that's capture rather than corruption. And also sometimes it's hegemonic, that regulatory officials believe, as the Americans used to say, what's good for General Motors is good for America. Well, often what's good for General Motors is not what's good for America, like putting heavy tariffs on Chinese electric vehicles, which are more environmentally friendly, to allow General Motors to survive with its old world internal combustion engines, would be a good example of how that hegemony really has to be challenged by new environmental values and environmental thinking. So we need responsive escalation in our regulatory agencies. And to reflect back to my own presentation, I think an independent accountability and integrity branch can call environmental regulators to account when they are being captured, when they are being corrupted, and when they are caught up in the hegemonic power of big business. And that's where that special dose of independence and autonomy, I think, can make a big contributions to making our democracies more generally, genuinely democratic and more effective at saving the planet. Thank you.
Yeah, thank you, Prof. John Braithwaite, for your response. And next we go to the Prof. Andre. Please share your opinion.
Okay, thank you very much for all very challenging and interesting questions. First about the my opinion about the remarks from Pak Jeff. Can we still claim that we are the protector of the environment? I don't know, but I think my presentation as this is my hypothesis. We have to prove it, of course, but my hypothesis why we have this such a very bad system of proper, although it can be easily improved, right? And it's not happening yet. I don't know why, but I think one of the reasons why we have so poor ineffective enforcement of law in Indonesia is because we have the term called pembinaan. I'm struggling to translate it into English. I think it's kind of cooperative and facilitative supervision. So instead of enforcing the law and give sanctions, the government and the regulatory officials who tend to give advice. And sometimes they give advice again and again and again and again. So it reminds me actually what Professor Braithwaite already stated in his book with the heirs, that corruption can tend to occur where there's a cooperation itself is not really bad, but sometimes cooperation between the regulators and the regulated communities, the industry, could lead to some, as I said before, corruption or capture. So it is more likely in a case where the officials has a close relationship with the regulated communities, and they have intensive cooperation with the sanctions, something like that. And I think this is interesting. I quote Professor Braithwaite, your statement. Cooperation corrupts. Cooperation qualified by the possibility of defection corrupts absolutely. And that's happening, I think, in environmental law in Indonesia, in many cases. Because that clearly shows how the government is so, I mean, to some, it seems that they, in many cases, they conducting, I can call it cherry picking, random, I think cherry picking cases to be brought into the to escalate into higher sanctions, more severe sanctions. But in other cases, even for serious cases, they tend to be more lenient. So like give advice, something like that, and again and again again. And for Faki, I think shaming and naming to others, I think it could also be conducted, but the problem is, I think the easy low hanging fruit for this thing to happen is hotels. That's what I'm thinking about. I mean, because it can give the power to the consumers. Then the consumers can choose, right? So for other products, for other industries, I don't know, because sometimes it does not really, I mean, many factors can influence our choice. But for hotels, I think information about the quality, environmental performance of the hotels could really affect our choice, right? I mean, so it could be done for other issues, but I think it can be easily done for the hotels. That's the thing. And for the Lapindo case, why the company got good rethink, I don't know why, but I think it also relates to the way the ratings is conducted, because the rating is basically heavily dependent on the self-reporting from the company. So the company gives a report, and then of course they will say good things, right? I mean, if we give report to the government, we will not say that we are bad, have bad quality environmental performance, right? So they will say good things, and I think the problem is in the verification process. Again, in many cases, the government give the time for the companies to make the improvement with the pembinaan, and many things can happen during the pembinaan, right? During this facilitative procedures, and I think that's what makes some companies that should not have been rated good get actually a good one. For Matthew, I think this is very interesting. It has been long debated actually between the environmental protection on the one hand and economic development on the other hand. But I think we can relate to, for example, the Kuznets curve. So I mean, the destruction of the environment of a country, it will get bad when a country starts to develop, and it will get better improvement after they come to the certain income. The problem is, for Indonesia especially, we have been told this one since long time ago, and since Suharto, we need development, and so we set aside the environment. We have to develop, but then what happened? What we have is just environmental destruction in Kalimantan, and in Sumatra and in Papua, and this environmental destruction, extractive operation has not been translated into welfare of the society. No, that just, I don't know where the money goes. But so it also solves what we call weak sustainability. We can destroy the environment as long as it can be translated into welfare. Again, the problem is that it doesn't happen in Indonesia. We destroy the environment, we destroy forests in Kalimantan, in Sumatra, in Papua, and still we don't. I mean, the people there still not in a good condition, right? Economically. So then we can. I think I should remind you about the. I don't know if you agree or not. Professor Nicholas Robinson from Pace University once said that sustainable development is not understood very well by the country. As a result, this term sustainable development is used to cover the continued practices of unsustainability of development of that country and sustainable development of that country. A more stronger opinion given by Professor Luis Kotze, saying that this sustainable development is actually an ideology to mask the continued plundering of the earth. So I think we have to be critical about this kind of because now we are not in a normal situation. We are facing many environmental crises now. So I think in that sense, I tend to agree with the court decision in Tanjung Jati A, saying that under the situation of crisis, environmental crisis, sustainable development should be translated as put the environment first and development later. So more on the protection of the environment. It cannot be neutral and be functioning as a bridge to balance these two conflicting interests, but instead to put priority for the protection of the environment. That's I think my answer.
Thank you, Prof. Andri, for your answers. And we go to the Pak Aderito.
Yeah.
Your response, please.
Yeah. Can you hear me? Can you hear me?
Yes, we can hear you.
Yes. Just quick one, I think. Let me start with the third question from Mr. Marvin on the KPK, and I think there's always the challenge of this kind of this anti-corruption commission around the world, where when you start to do your action and then power holders try to intervene, and then we saw that, and I guess, like, if we talk about the technocratic commissioners or staff, let me put in this way. I think when you talk about anti-corruption commission, when you talk about combating corruption, it's just not a technical issue. It is a political issue. So we have to have kind of good political economy analysis on the situation, on the institutions, on who are who in the town. And I think if I follow the KPK closely from the outset, from the establishment up until now, I guess suddenly we all put kind of energy to KPK, which is good, but there are different what I call as the oversight mechanism. Not only KPK, we have Komnas HAM, we have inspectoral, for instance, in each department, and we have different mechanisms that you have in Indonesia, what I call is oversight mechanism. And that's bring me to what I think, again, it's hard not to refer to your intellectual mentor when you're sitting together, what John called as the network governance, that you identify the nodes, you identify all the actors that involved in that. So there are different oversight mechanisms in town that we can't just give all the hope, all the energy to KPK. If KPK fail, we have to have different mechanisms to do that. That's what I call as the oversight mechanism. We have KPK, we have Komnas HAM, we have Ombudsman in Indonesia, we have inspector. I bet like you have inspector in each department, if each ministry, they also play this role. So this is, I think, the challenge for efforts to combating corruption. So we have to have good political economy analysis on that situation, on how to do, on how the effort to combat corruption. And of course, I follow that Indonesian case. We face the challenge at the court itself. We all know that just this month, for example, how KPK, or I think prosecutor attorney general office, found that senior staff of Mahkamah Konstitusi, Constitutional Court, or where he has huge amount of million of US dollar in his house. Can you imagine? This is the senior staff of High Court in Indonesia. So we have really serious problem. So that's just to relate to my dear Professor Jeff Kamel. Good to see you again. And I am a bit disappointed that I can't make this time to attend personally in Satya China, but I promise to come next year. What I learned from John is, whatever the situation that you found, it can be very tough, sometimes make you frustrated, but you always have the hope. And that is all I'm advocating in my own country. I'm not no longer in the government, but I work to support from the background to support all these oversight mechanism. My old office in Anti-Corruption Commission in Delhi, the Office of Ombudsman and Human Rights, the Prosecutor General Office, the Inspector General Office. We are doing kind of investigative journalists to train journalists how to do good investigative journalism, and also few NGOs that are doing work on good governance and anti-corruption. So I think, I followed, now we have Mr. Prabowo as the president. I follow very closely Indonesian politics, to be frank with you. I followed, for example, this week about the election of governor in Jakarta very, very closely. I followed it very closely. And I guess the challenge is how to open the space for civic participation. I think that's the challenge. Whatever government, but if you don't have this space, civic space to have dialogue, I think that will be a challenge. People raise about the human rights violation that still not been tackled. When Jokowi came to power, he promised to tackle the human rights violations, especially about the kidnap of many of my friends. Actually, 10 of them are still kidnapped, and and it's not resolved yet. And I guess we just need to create this space of dialogue, be NGOs or academic or or private sector. We have to push for. I will be disappointed if the civic space in Indonesia becomes shrink. That will be disaster for us. That will be disaster for Indonesia. But as long as the civic space are open, I think we still can advocate in different ways, in different manners. So that is my very general comment about Indonesia. But believe me, there is always hope that I'm learning from my dear intellectual mentor, John Braithwaite. Thank you.
Thank you. Can we give applause to all of those speakers? Yeah, unfortunately, due to the limited time, we have to end the Q&A. So I hope that all the discussion that we've been through until now has enriched your knowledge, our knowledge together. So if I can wrap up a little bit about the discussion about this session, Prof. John Braithwaite lays down a very principles explanations about the strengthening separations of power and democracy to strengthen the role of the state, and also it can be implemented in many areas, such as what we have heard from the two speakers, two other speakers, Prof. Andri and also Pak Aderito, in their areas respectively, in environmental law area and also the corruption area. I hope that what we have discussed in this session could be fruitful, to strengthening the role of the state in securing peace, order, justice now and in the future. So that's the wrap up for today's second session. So I cannot wait to look forward to seeing how this discussion will contribute to our knowledge in the future. So thank you again. Appreciate your participation for Prof. John Braithwaite and also Prof. Andri and also Pak Aderito. Thank you and
Thank you. Terima kasih.
terima kasih kembali, Pak. I will give back to the Master of Ceremony, Mbak Michelle.
Once again, give applause to Mrs. Ninon as our moderator and all our speakers for the second session seminar. Thank you very much. We invite the speakers and the moderators to return to their seat. The complexions of second sessions and seminar has opened our perspective and opened up new insights for all of us. We want to extend our heartfelt thanks to all the speakers in these sessions. We hope that first seminar sessions has provided a meaningful for everyone. We invite Professor Umbu to present a placard to the speaker, Professor Andi. So we will welcome to the stage and take the documentations. Give an applause to Professor Umbu and Professor Andri. Ladies and gentlemen, today's conference has been concluded, and I definitely feel grateful for that, and I hope all the audience feel the same way. And finally, to conclude today's conference, I would like to invite Ms. Abigail Prasetyo, SIMH, to the front to lead our prayer.
Okay, good evening, ladies and gentlemen. Before we wrap up our first day, let us pray. Please allow me to close this first day of NICGL with a prayer, and I will lead the prayer in a Christian faith. So for those who have a different belief, please may adjust. Okay. Okay, let us pray. Our Father in heaven, praise be to you for your grace alone, so we can complete our today's conference. Lord, now we will return to our respective places, but we believe that we will not that you will not leave us. Please return us to this place tomorrow in a good and healthy way, and also joy to attend this conference in a good health. We ground this prayer in the name of Jesus Christ, we pray. Amen.
Thank you, Ms. Abigail. Ladies and gentlemen, we have now reached the end of the program. Hopefully today's event can add new knowledge for all of us. But first, we invite all presenters all invitations and speakers to take a place in front of the stage, and we will have photo sessions together. Everyone, maybe you guys could stand up and take a place. Also, all of the participants today in this room, we will have a photo session together. We would like to say thank you and see you on the second day of the conference tomorrow. Everyone, there's a exit ticket that you can access at the end of this conference today. Please take a look at that exit ticket and go over it. You guys could scan the exit ticket in the screen. Thank you.